Yes.
Item 1 for delivery of order.
This is the review. The contempt petition is closed for the reasons which we have given. Give it to me for perusal.
Supplementary list, item 42 for delivery of judgment.
Advocate was informed of the date change. Date change कर दिया. The review petition is dismissed. Published. The practice is to give the judgments, the delivered judgments to the advocates for perusal for a while, to be returned, not to be taken out of this court, unless it is pronounced. Yes.
Adjournment request, if any, from item number 2 to 5.
My lord, item 2, my lord, we are praying for 2 more weeks to file our.
An adjournment slip has been circulated. That this matter, the legal counsel for the respondent does not have any objection. Re-notify your date in January. Yes.
9 January. Item number 6 to 16. Item number 27 to 37. Adjournment request.
May I please, as your lordship? My lord, I beg to mention, my lord, item number 31, my lord.
No, it is only for item number 27.
27 to 37.
27 to 37, yes.
My lord, I beg to mention item number 31, my lord.
Yes.
My lord, may I pray for at least 2 weeks more
Have
accommodation?
you informed the other side?
My lord, the government is only the other side, my lord.
So you have to inform.
I have informed, my lord. I have.
Perhaps Advocate General was appearing in the matter.
No, my lord, only the government advocate, senior government advocate, my lord.
Item number 31.
My lord.
31. All right, as prayed for. On behalf of the appellant,
My lord.
let this case be listed for consideration January.
21st January.
My lord. Obliged.
From item number 38 to 41. Adjournment request.
May it please, lordship. I beg to mention item number 39, my lord.
Adjournment slip has been circulated. The council on behalf of the there is no objection to such adjournment by the council for the respondent. Re-notify January.
21st January.
Yeah, please, your lordship. Lordship, I'd like to mention item number 40, your lordship.
40.
Yes,
Yes.
lordship, this matter may kindly be adjourned for today, your lordship.
Adjourned for
Today, your lordship.
today. Today, tomorrow, I don't think it shall be listed. We will give you an adjournment, but then it goes in January.
Okay.
As prayed for on behalf of the appellant, re-notify sometime in January.
Yes. 28th January. Any other request?
May it please your lordship. Mother, with an apology, my lord, I'm praying for listing of a writ appeal filed yesterday. The order was passed on 15th of October, few days, holidays were there. today, my lord. Otherwise, it becomes infructuous, perhaps by the end of the day.
By the end of the day, it
By
becomes
the end,
infructuous.
one view, yes, if lordship says, if I'm able to satisfy status quo ante on the election, then it's a different issue. Otherwise, just a consideration, nothing more. I pray for that accommodation, my lord.
What is the issue? I mean, that's only, the purpose is only, otherwise also it shall be listed. But listing it in priority for tomorrow and day after tomorrow, you need to explain what is the urgency,
Today,
what
I'm
is the
saying,
issue.
actually. Today, it will be, Saturday would be a holiday. Saturday would be a holiday.
Very well, at 4 o'clock, at 3:45. We have another bench with another conversation. So I think 3:30. 3:30.
Grateful, my lord. Obliged.
May I please, your lordship?
Normally, with such mentions, ultimately it is found that the heavens are not falling. It's only the
It's on the way down.
urgency created by the council.
So
That's
it's
the-
for us in the matter, it's on the way down. Obliged, lordship.
It's not effective, huh?
May I please, your lordship?
It's not effective.
With consent of the respondent, I beg to mention item number 45, lordship. Sir, kindly adjourn for 1 week, lordships.
Item number 45.
45, lordship.
45, huh?
Supplementary.
Is there an interim order there?
Yes, lordship.
Then it will be difficult. Interim orders, we don't grant adjournment.
Only for 1 week, lordship. Conducting council, Mr. O.P. Bhatt is out of station. Only for his.
Have you informed the other side?
Yes, lordship.
Lordship, I am for the respondents.
No objection?
Okay.
A request has been made for adjournment of this case by the learned counsel for the petitioner. The learned counsel representing the respondents does not have any objection. List this matter on your date in December.
3rd December.
Obliged. Interim is there.
You will have the liberty to file an application for vacating the interim stay if it is unnecessarily delayed.
Obliged.
Yes,
3rd December.
May I please, your lordship? In item number 8, your lordship, as directed by this honorable court, where I have filed,
nothing. You don't write it. Yes.
may I please, your lordship? In item number 8, as directed by this court, we have filed a points for argument, lordship, yesterday. In that points for argument, in the last portion, one typographical mistake was there. Instead of government land, we wrote it as TB hospital. I brought fresh
Item number
copy.
8.
Yes, your lordship. I brought fresh copies. I may be allowed to serve it.
That's all right. You point out there. No difficulty. There are many mistakes. Otherwise, we condone it. We read it correctly. All right. Yes. That
Yeah.
you need to mention, Mr. Counsel, only if there are factual errors. If there is some minor dispute that can be taken care of. Doesn't matter. Yes.
Daily list for orders, item 3.
Yes, Mr. Chaudhary.
Lord, I'm thinking of relieving, rather I'll be making a prayer to the honorable court to relieve me from this task of amicus. Because, my lord, when people don't understand what is the meaning of public interest litigation, there is no point appearing. When state considers this to be an adversarial litigation, and in fact, what had happened, my lord, because of this artificial flooding in Guwahati, an unprecedented flood took place in the 24th. Then I, based on those newspaper report, I placed it before the Honorable Chief Justice. Based on that, this was registered and I was requested to act as a amicus curiae. Over a period of time, my experience is not good, Miller. Because these are not adversarial litigations.
Now, that's true, Mr. Chaudhary, but you would appreciate that an amicus is a friend of the court.
Yes.
Now, whether other side recognizes your worth or
No,
your
it's not a
efforts.
question of recognizing my
or
worth. When the cause,
And the cause is all right. You assist the court. So when you're assisting the court, why do you ask for your being relieved?
For example, my lord, in this case, a foreign firm has been engaged at an exorbitant price of 12 odd crores for preparing the DPR. We made suggestion this can be done locally by spending about 2 crores of rupees. Nobody is listening to us, my lord. That's why I felt no point.
Now you can raise that as an issue. We will put it to the Advocate General. You can raise this as an issue.
So, my lord, end of the day, this is a perennial problem.
Mr. Chaudhary, try and understand this.
Anyway, I withdraw
this-
that request, my lord.
in
I'll
this-
continue to
no,
associate myself.
Let me explain it to you.
Yes.
Why your request is not being acceded to immediately. If you say that you don't want to work, all right. But then why it should not be acceded to immediately is that, you assist the court. The court would require the assistance because this, you were made an amicus by an order dated 26/5/2025 by the predecessor bench. Now you have done your part. We would require your expertise here. Now, asking.
Anyway,
yourself-
I withdraw that
asking
request.
to be released. You see, you can always raise objections. You can point out whether it will find favor with the court or not, whether it will be accepted. That's a different question altogether. You have to be an impartial friend of
No,
the
my
court.
lord, my
Lagging.
perspective was whatever had happened had happened. Let us make a beginning how to mitigate the hardship of the people. So nothing seems to be done, my lord. Only in affidavits everything is being done. But people are
Let's-
not getting the tangible results. I think, my lord, Honorable Justice Arundev Chaudhary can very well vouch for what I'm saying, my lord. What is a little spell of rain, disaster happens in Guwahati city. You should do a beginning, how to mitigate the hardship of the people. The efforts are not visible, not tangible. Every time, my lord, there is a rain, there will be a.
No, where have you suggested?
Yes, my lord, there are certain factors. For example, flood water comes from Meghalaya side. That is also one of the problem. But last 2 years, we're only discussing.
No,
Nothing.
have you given any suggestion to us?
Yes, my lord.
Where is it?
My lord, in fact, my lord, one of the person, he was former executive officer of the Guwahati Development Department, my lord. He has also come up with some suggestions. I'm just putting it forward, my lord. You have the copy of the vehicle. বুঝিয়ে না তো। তাহলে কি তো হাজিয়া হবো আমি। হ্যাঁ? তেরো কোটি টাকা কি কিছু না খালি ডিপিআর বানাবো কেন করি এই যে ঘুমে থাকি দেখলে হঠাৎ কিছু না একটা প্রোগ্রাম করানো ঠিক একটু জীবন দেখ
Mr. Advocate General, you have a copy of these, copy of this suggestion.
Yes, I do have, Lordship.
Now, with respect to the legislative or regulatory suggestions which he has made, what do you have to say? Number one has to be seen with some circumspection. The building permission cannot be stopped altogether.
Lordship.
There has to be a balance.
Yes.
But building permissions only after attaining all clearances. Now, all hill cutting should be banned in Greater Guwahati for a period of 3 years. I think this you must ensure.
This we have already done, not only now, long time back, and it is properly monitored. Now the problem of hill cutting is in Meghalaya.
That you cannot control.
That we cannot control. For that also, we are trying to adopt certain measures, and the matter is pending before Supreme Court. We have very pinpointedly indicated from where the problem is created. Now, the Amicus has very correctly said that nothing is visible. I just defer to that. Earlier, Guwahati had 16 number of wards. In that ward, our main area of waterlogging was in Santipur. My Lord Justice Chaudhary will aggregate. Anil Nagar, then some areas of Silpukhuri.
Okay.
There is absolutely no water accumulation in Santipur now. This is a thing of the past. So far as Silpukhuri areas, everything is clear. Gitanagar area, no problem now. Everything has been rectified. So far as Anil Nagar and Torun Nagar are concerned, earlier we have to have the water for 3-4 days accumulation. Now within 20 minutes, it is cleared.
You have the pump.
We have all the pumps, everything.
Some houses.
Every pumps are there. If Lordship can direct any commissioner from the court also, they can go and visible. I can personally go and show them also. Now within 20 minutes, 30 minutes, the water is cleared. What is creating problem? The television channels take the visuals at the time when the water was there. And it was repeatedly played. That is why the perception has been created that it is going on for the whole day. No. The people there, it is, I mean, that is the lowest point. Tarun Nagar and Anil Nagar, if Guwahati is just like a bowl. All across, we have the hills, the water comes and it accumulates. That is the deepest part. In fact, one of the suggestion was that we have to translocate the whole community from there. That was one idea mooted about 7-8 years ago. But it is not possible because everybody is well settled there. Now the new problem has cropped up for last 2 years. And if Lordship is pleased to take my affidavit.
No, we will take, but just we want to know, good building
Yes.
permission.
Building permission, that is not the problem. Building permission is not the problem.
All right. Now, the reserve forest within Greater Guwahati should be made encroachment.
Yes, that is why even yesterday also we had a case of this Barsapara area, the hills, all were encroached and that litigation is going on. We are awaiting the final judgment. We are going to clear the reserve forest. There are large scale encroachment in that particular hill. Other hills also we have already identified from where the encroachment has to be removed. There is not a single PIL in the court to remove the
encroachment.
In
fact,
from the hills.
Cases are filed for
the reverse. The reverse is going on.
That's right. But then simultaneous process of plantation also should be carried out.
We are doing it, Lordship. We have a policy. If one tree is uprooted, it has to be replaced by 10 trees. And forest has a huge afforestation project, and we are spending crores of rupees in afforestation. And in Assam, we are having a project now for implanting 1 crore trees, and Guwahati is part of that project.
We will get back to all this.
Yes.
Subject to what we find from your.
Now this new problem has cropped up because of the hill cutting
in Meghalaya.
No,
we can.
If Lordship, when the aircraft is landing in Guwahati Airport, Lordship, if Lordship is pleased to look at the right side, I always feel that why we are cutting the hills. All these areas are belonging to Meghalaya. In fact, tomorrow I'm going to go for a motorcycle ride in that area. We'll have to find it out. Large scale, that is why the airport is also affected. And also, Lordship, the Jorabat, we have never heard that there is waterlogging in Jorabat. But that is a common phenomenon now for last 2 years. And we have identified from where the problem has cropped in. One university has been established large scale violation of environmental laws. Supreme Court has already issued notice. All these things are going on. And now the major water logging is happening in Rukmini area, Rukmini Gaon and Khanapara area. And the national highways also, we have now planning to have some culverts and drains cutting across the road.
All right.
Those are not within the domain of the state government. That is the National Highway Authority's area.
We'll be recording all this. Now, what about this suggestion? All the non-Miadi Patta land should be surveyed properly and no big structure should be allowed on those lands.
Certain things are acceptable, certain things are totally not acceptable because we have building bylaws in place. Whatever is going on, it is as per the building bylaws. Everything is in place. There may be some aberrations somewhere, then those cases are also coming up before the Honorable Court.
Now, have you formulated drainage master plan?
Yes, that is what.
The new one?
Yes, Lordship, that is what. 2 years ago, now one of the submission is that because proper facts should be found out. That's why we have given it to an agency from Netherlands. It was done through a proper tendering process, RFP. There were 4 agencies participated. One is Haskoning, that is from Netherlands, Shah Technical Consultant, Tata Consultancy Engineer, and Webcos. 4 very reputed agencies participated. Tender was of February 2024. After a detailed process, fair and transparent manner, one agency has been given. And why we have selected Netherlands? If Lordship knows the geography and terrain of Netherlands, the whole country is below the sea level. So their expertise we are taking. So they have started the work from September 2024. They had taken 1 year's time to do the whole mapping of the city where the drainage is, because they want to see it during the winter months as well as during the summer months, the rainy season as well as the dry season. They are now submitting the final report and we are already starting the process of acquiring the fund. This will be a massive exercise. It cannot be done overnight. What my learned Amicus curiae is saying that it is not visible. These are newly created problems. The major problem is coming from Meghalaya.
What do you suggest for Meghalaya?
The Supreme Court is taking care of that, Lord.
The matter is pending before Supreme
Yes, Lordship.
And there is effective
Very
representation.
seriously, Supreme Court has came up.
Very effective representation on behalf of the state of Assam.
There are some public interest litigations, persons are there.
Your
State government, I don't think Assam government is a party there.
No,
Let me verify because
Assam
one of the council.
should.
No, yes, Lordship. Let me get that clarification because Nalin Kohli, one of our council, he is appearing in that case. Whether state is a party or not, I'll try to find it out.
All right. Then encroachments by private entities on public lands, particularly over drains and infringement of road, should be mapped. and
That is a
cleared.
continuous process. We are clearing the drains. The problem in Guwahati is, Lordship, we have to appreciate that. We every year during March to May, we clear all the drains. And in the first spate of rain, the soft soil from the hills comes and blocks the drain again. That is a major problem. This is a geographical problem. Because of large scale encroachment on the hills, the erosion is taking place.
So that's primarily because of afforestation.
If deforestation, we are trying to have, we have various measures, but the problem is that these problems has been not overnight, it is happening. We have lost the plot of Guwahati in 1970s. When the capital from Meghalaya was brought to Guwahati, Shillong was the earlier capital of Assam. At that point, there was a large scale, everybody is trying to acquire land here. There is no proper planning, nothing. Therefore, Guwahati has to spread North Guwahati as well as to the other areas near Mirja and Chaigaon area. These are the historical problems we are facing. If we have to go to some areas which are post localities in Guwahati, like the Jew Road area, 2 cars cannot pass the interior roads, the arterial roads. And nobody is ready to give up 1 feet of land also. That is the problem. For government, constructing the drain is not an issue. But it will be huge cry by the public. So there are certain practical problems we are facing.
Where is your affidavit?
My affidavit, Lordship will take the last affidavit, which 568.
Separate pull-out. This has become unwieldy. I have been asking my courtmaster to, arrange it for me. This becomes very unwieldy. If you have a separate pullout, you can
Yes,
give it.
I have, Lordship. I'm sorry, I may not have two, but
we
at
will
least
read
one
together.
copy I have. So this problem,
My brother can very easily navigate through the bulky petition. I require a separate pullout.
Lordship, this also I would like to show that the tender process document, just for a cursory look.
All right.
Because certain comments, when it is comes, Lordship, in the next day, the social media will give a different twist. That we are not going through a tender process, we are giving it 2 crores instead of 12 crores. All these things come
Mr.
up.
Advocate General,
I understand my limitations also, but I have to,
Mr. Advocate General, look at this. Now, what I-
without knowing this, the statements are being made.
no, I'm telling you something
And
else.
these are in part of affidavit also.
That's true. That is real politic. But then try and understand this, that when you
This-
run a state,
Lord. No, we are ready for that, Lord.
No, when
It
you
is
run-
not that we are shirking off our
when you
responsibility.
run a state, or when we run the judicial administration, we ought not to be wary of this public perception which is
I
created.
understand, Lord. That is why
We-
I have whatever I have said.
The state has a broad shoulder, so has the judicial.
We always appreciate. I am appreciating when this PL first came up, that there is a prayer for stopping hill cutting. And if the old recordings, I appreciated this, Lordship, that this is what we want. Next, it is I am waiting for that PIL when somebody will take up the cause of removing the encroachment from the hills. So if Lordship is pleased to page 570, the detailed project report of the Bahini Basin.
1 second, give us
Lord.
1 minute.
Lord, I'm sorry. Yes, sir. এখন কোথাও দিছি আমরা? ফটো তো ফোন দিয়ে দিব কইছিল না? এখন দিলা। এখনো দি দিয়া। আরে মূল লগত আছে না এখন? কি বলতো দিতো? ভাই স্যার। তুমি এখন লিখতে হবে। আমার part of that. এবং ভারত প্রোগ্রাম দুটি কথা বলতে তুমি আমার আপনার পিঠ মুখ বড় পটের পয়েন্ট এটা তোমার গলি গলি কি বল আগে মই মেঘালয় বস্তা বলে যাম
Which out of the 4 agencies has been selected?
In the first phase participated.
No, which has been selected?
The first one, the Husk H, the name starts with H.
Has
It's a Dutch company. We have given the reports also. All the detailed reports are part of the affidavit. Their preliminary report and the final report is also we have submitted. Very elaborate mapping has been done with the contours and the gradients.
And it has also formulated, it is in the process of formulating the master plan, master drainage.
Yes, Lordship. In the affidavit, we have said, page 570, let me read paragraph 3 onwards, Lordship. Very short affidavit. That this instant affidavit, have Lordship got it?
Yes,
569.
yes.
That this instant affidavit has been filed in compliance of the order dated 26/5/2025, passed by the Honorable Court, whereby the state of Assam has directed to furnish a detailed report regarding a flood mitigation measures taken in pursuance of the report submitted by the consultancy agency, Royal Haskoning DHB, to mitigate the problem of flood in Guwahati. The measures taken by the state of Assam in respect of the same are as follows. The detailed project report of
That we have read, Mr. Advocate General.
Lordship.
Now, what was he saying? What was Mr. Chaudhary saying that there is a local consultant also which can?
That is their perception. We do not have that perception. We have to follow a tender process by following the mandate of Article 14 and 16. If we select one by giving 1 crore rupees, then that will be in violation of the overall constitutional provisions. We cannot pick and choose. We have to open a tender with credentials requested, and these are the expert bodies who have participated, and they are including a Tata Group also.
Tata and Shah Technical Consultant.
Yes, Lordship. These are expert bodies. This is not a child's play.
And what is this proposed mitigation strategies?
Yes, now,
by
Lordship.
Akashdeep Barua, IFS.
Under the major intervention proposed and approved include, Lordship will kindly take page 570. Diversion of the stormwater from Meghalaya catchment along the national highway to Pamohi River. For that, we have to cut the road, highway. Because the water, the hills are on the other side and the Pamohi River on the right side. Left side is the Meghalaya hills. So that is the creation of problem. Enhancement of the Bahini River's carrying capacity, including construction of proper retaining walls and slope construction, creation of retaining pond at 6 mile on the EPDCL land with a provision for pumping water to Sil Sakubil, where we have started large-scale encroachment clearance for last 2 years. It is at the final stage. We have removed some hotels. We have already removed one academic institution of research institution, Omio Kumar. Then also the tennis court, there are a huge tennis complex. That also is, the Honorable Court has already directed to remove them. The process is going on. Then additional diversion of water from Pipo Point to Sil Sakubil. Quick evacuation of water from Rukmini pumping station at Chinakipot to be increased. Additional drain to be created at Patkai with a dedicated pumping station.
From your affidavit.
From my affidavit, Lordship. Paragraph page 70, 1, 2, 3, 4, 5, 6. The next page
When-
also,
Mr. Advocate General, can we ask you, when would this be visible?
this will be visible because the next paragraph, Roman 2. In addition to the ADB funding, the National Disaster Management Authority has committed approximately 200 crores for the above. So the process has started.
So that's right.
And total, we have
By
to
the-
construct 328 square kilometer areas drainage.
That's right. So
It's a huge investment.
by
So
the
we have to
next-
arrange the fund.
No, that's right.
And it will take,
That's
Lordship,
what we understand. It's not a,
it will be taking 2 to 3 years time
you rightly said,
to mitigate the earlier problem of Santipur, the Gitanagar area, or other places, Lordship. It took us 7, 8 years. It will take time. Here also it will be easier because for construction of a drain in the national highway, it will not take much because we don't have to remove any encroachment there.
but in the process, the
Short-term measures are going on, Lordship.
short-term measures.
Definitely it is going on. And this actually had happened in 2024 in the month of last part of September or first part of October, a major disaster had taken place, just like the Mumbai incident. Overnight rain, then that has actually opened the eyes of the government that the problem is being created from Meghalaya side. And new areas are inundated. New areas are affected. Earlier, the Khanapara area, the 6 mile area, the Rukmini Gaon area, Lordship, these are all on a higher elevation. There was never any issues, or even this Beltola Road, Lordship, Survey Road. Flood was never a part of those areas. These are newly affected, flood affected areas. Hatigaon area. Earlier, Lakshit Nagar, then a little bit of Silpukhuri, Anil Nagar and Torun Nagar, and Santipur area. RG Budwar. These are things of the past now. Lordship will not find a single drop of water accumulating in RG Budwar now.
RG Budwar, I think there is still.
Within 5-10 minutes issues, because there are large scale pumping stations where earlier it was inundated for 3 days, 4 days, 5 days. So Guwahati's geographical terrain is like that, Lordship. It is not that, it is not like Gurgaon in Delhi. It's a flat area. Guwahati is not a flat area. And 20 minutes, half an hour, because the rain comes from top and it accumulates in that area. From there, we have to pump it out. And there is contribution of the civil societies also. When we have created the walls. আমি গার্ড ওয়াল বানাবো তারপরে ঘর ড্রেনের পানি পেটাতে পারে So I can submit a status report, Lordship. What is the progress now? If Lordship is monitoring, Lordship, the things will move at a much faster pace.
Take it.
My lord, I have a suggestion.
Yes.
My lord, art cutting is, sorry, hill cutting is taking place in Meghalaya. Assam police cannot control. I accept that.
No, we can.
No, my lord, there's a second thing. How those arts are running through the Guwahati city at night? Who permits? My lord, coal comes from Meghalaya every day. Whoever comes from Shillong to Guwahati will find at least during that 2 hours, at least 20 trucks crossing, or you're crossing the trucks carrying coal. But there is no coal mining. Why Assam police permits? Why Assam police permits them to bring to Guwahati?
No.
Some of that art cutting in Meghalaya,
Chaudhary, I understand. that.
Yes.
But you can't stop the transport. No, it's inland water. I mean,
Then
landlocked state.
they must have a transit pass.
Transit pass, transit
They
permit.
invariably
regulations.
don't have. So this commission Raj is going on. So therefore, my lord, at least they should be stopped. All right, you are cutting hill from Meghalaya, do whatever you like there. Assam police we cannot do, but we can certainly stop this truck carrying those earth. Why that is, my lord, when this national highway was constructed, people are, my lord,
So can the government do that? It just a minute.
why not, my lord?
Constitution.
No, 302 reasonable.
302 to 307
No.
would be offended.
No, my lord, reasonable restrictions can always be there.
Reasonable restrictions,
Yes.
you're right, during night time, but then you can't stop the passage.
No, what
That
I'm
be
saying
acting
is, my lord, they must.
May I just submit? We are digressing from the issue. Why I'm saying? Because the hills are cut not to supply it to some other places, the soil. It is for landscaping purpose, for having the university area, for having the petrol pumps, for having various buildings.
Even government department, they're using this soil.
For that,
Even
we have
National Highway, my lord, when these flyovers were constructed.
sufficient number
all
of
those lands
reverse
were
hills here
utilized.
in Brahmaputra.
No, we are seeing in naked eyes, nobody is doing anything.
No, but what are you suggesting that?
What I'm suggesting is, my lord,
This,
some government, if it cannot stop hill cutting in Meghalaya, then they can certainly stop those trucks carrying those soil to bring into Assam.
how would that affect drainage?
You know, then, no. Eventually, my lord, they're blaming now everything is on Meghalaya. Guwahati flooding is because of Meghalaya, everything is because of Meghalaya. There's one university, everything is on the blame is on Meghalaya. Because they have to shirk the responsibility by saying something. My lord, we all know Netherlands is not an expert in flood management. Netherlands is expert in stopping ingress of seawater into their place. Netherlands is never an expert in flood management. We also know, my lord. We can Google it and find out everything nowadays. My lord, to make a DPR for this project, there are enough experts in Assam. There's a gentleman called one Khatonian, my lord, is a very good architect. He has given plans. Nobody's, who will listen to them? Because there are some people sitting somewhere, they think they know everything, right from rocket science to everything. So they can do anything, whatever they like. And it's happening. There's none to oppose, things are going on.
Lordship, may I just, no, there is another issue. which has been tagged with this present PIL, that your lordship will find flag Y. This is with regard to construction of a school. And precisely the issue is with regard to cutting of a hill. This is
School where?
Gurukul in the Gitanagar hill area. The school initially started with a small,
Itanagar, that's Arunachal.
no, Gitanagar,
Gitanagar.
Gitanagar here, my lord.
Okay.
Initially, the school started with a small building. Now, cutting the entire hill without any permission, they are constructing buildings after buildings. Flag Y, if your lordships kindly have a look. I have been requested by senior citizens to just flag this issue before your lordships. Although they have represented before the Honorable Chief Justice, no separate PIL was registered and the representation has been tagged along with this PIL. So this issue remained dormant, my lord. This issue, because of the earlier issue, has remained dormant.
अपने से कर दिया तुम अपने से कर दिया करो not
It contains photographs also, my lord.
we'll take note of this. All right.
Some report from the state has to be called for regarding this. What permission they have got for digging the entire hill, my lord?
That is not in Meghalaya. That is in Assam.
We'll put them in a different way. ये पूरा हिल में है
If your lordship
This is for the consumption of Mr. Chaudhary and Mr. Advocate General. Now, the experience in the past in different states have been very different. You know, this many a times people say, and rightly so, that reckless construction activity leads to all this. That's one of the grounds. Now, we tried it once by controlling the supply of sand. With the control of supply of sand, two purposes would have been served. The river course would not have changed because of excessive mining of sand, for which there are mineral concession rules, very strict rules, but not followed. Because every day, you know, trucks without challans, they pass through cities and they are taken to different places. This is all illegal, you know, sand mining. And the other was lack of construction activity. I mean, stoppage of construction activity or restricting it, arresting it to some extent. But then such a furor was created that everything had to be abandoned. And thereafter, there was a spurt of construction activity in and around the capital of Bihar. And the government of the day, with the tacit approval of the judiciary, had to stop that. Now, you can't possibly do that. There has to be a balance. The measures which are there, the controlling measures which are there in various acts and rules have to be, you know, strictly enforced. That is on the executing authority. That's the government. But then you can't really stop it. Now, mud would be required. Stones would be required. So sourcing it from a different you know, location is not going to change the problem. That would only add to the cost of the construction activity.
Exactly.
So something which really affects has to be done. The first thing is drainage, of course, as you people have rightly said, stoppage of hill cutting, and then a master plan. This, along with effective implementation of the building laws, building bylaws, environmental clearance, all this is all connected. And the cycle is vicious. One breach at one place would lead to breach at other place.
Correct.
So therefore, a composite effort has been made. Let's see what we can do. We agree with the Advocate General that this cannot be done in 1 month.
No,
2
no,
months,
but
6
overnight
months.
it can't be done. Nobody's
can't be done.
expecting.
It has to be a sustained process and some kind of, change in the mindset of people. And that can't be changed overnight. There is a mindset of people to congregate at, centers like Guwahati. Or, I mean, instead of having their housing at some other places outside court. You see, if nobody wants to leave the vicinity of the capital area for convenience, little realizing that it causes lots of problems. And this problem began with the Industrial Revolution in England.
Correct.
It can be traced back to those times. Now it is to be done. These Article 226 or maybe 32 or maybe 142 would not be sufficient. Dissemination of information, mindset change, these are aspects which cannot be controlled by judiciary.
Correct.
That cannot even be done by the government because the government owes its authority to the electorate. Now, can it be said that no, ignore the opinion? I mean, something has to be done. A balance has to be struck. A very strong. We have the example of Punjab when Pratap Singh Karon was the chief minister. Now he was criticized in scathing terms about the construction activity which he started, spurt of construction activity, bringing within its train huge, corruption issues. But then Punjab today is Punjab because of those construction activities, because of construction of those dams.
Correct.
Schools and hospitals and all that, everywhere there is a problem. Selection site, Panchayati Raj institutions, how exactly to go without any opposition. The city can't be allowed to remain static. Because the city of Guwahati still looks like a subdivision.
Yes.
It doesn't look like a capital city.
No.
And so are other states. Since we are in Guwahati, we are talking about Guwahati. We don't make any comparisons, but it doesn't look like a city. So something has to be done. The construction has to be carried out. Bridges have to be built. Schools have to be built. Medical colleges have to be built.
So far as the old Guwahati is concerned, Lordship, it is already saturated. We have very limited things we can do here.
This was the reason.
That is why the expansion has to take place. And it's spreading also. North Guwahati is a hubbing area now. All the hospitals, main institutions like the AIIMS, then IIT, everything is there. North Guwahati side, all these Aero City type hotels will be all started their work. All the housing complexes are towards Mirza side, beyond the airport.
How can they control properly? Anyway, let's focus on things which
So
are
Greater
possible.
Guwahati will be up to Jagi Road on one side, then Polasbari other side, Rongia the third side, and this will be all encircled in a circular road, ring road. Everything now, the next stage of planning has already started. Not only planning, the work has started.
All right, thank you. Yes, we will flag that.
Sure.
We will ask the Advocate General also to look.
Yes,
into that.
status report, Lordship.
Flag why? Yes,
Yes.
yes. But let me first formulate
Lord.
things for all of you.
Lord.
Take it. We have heard Sri Kamal, Sri Kane Chaudhary, learned senior advocate, bracket Amicus, and the learned Advocate General. The thumb rule regarding the principle of drainage system is that water seeks its own level and flows from a higher level to a lower level, provided it has access to uninterrupted free flow. This may sound pedantic and or reflecting a narrow view, but includes within it the associated problems leading to artificial flooding, artificial flooding. These of new settlements in low-lying areas hill cutting in hilly areas for settlement, absence of long-term planning for drainage in the city and around, and reckless construction activities have contributed to the problems, not only in Guwahati, but elsewhere as well. The question is how to arrest and control it. This PIL has flagged issues relating to artificial flooding in the Guwahati region, ascribing this to primarily earth cutting activities in and around the city. By the aforesaid PIL, the petitioner NGO has sought judicial intervention to address the issues in a composite manner at a high level, there have been continuous illegal earth cutting activities and rampant encroachment which has further exacerbated the problem. The issue was appreciated in the right perspective in this PIL, and successively, we find, that efforts are being taken to control such illegal activities which has caused flooding. And since the problems date back, since the origin of the problem dates back to several decades, attempts have been made to formulate a long-term sustainable strategy for improving the drainage and restricting the factors which have contributed to such bane of artificial flooding, causing an environmental apocalypse. The learned Amicus has brought to the notice of the court proposals for mitigation of the problems and for tackling artificial flooding of Guwahati city, formulated by a retired IFS officer. We have gone through the same, which actually traces the history and the geography of the natural drainage of Guwahati city, the problems caused by the diversion of the two rivers, by diversion of the course of two rivers flowing through the city, and the disruption of the river systems by natural and man-made causes. Natural and man-made causes. Stop. It has also taken into account the activities in the neighboring state of Meghalaya, where there has been reckless hill cutting and extraction of soil for commerce. The suggestions for controlling the problems are A, detection of defective drainage through elevation profile analysis, semicolon, digital terrain modeling, bracket DTM, for laying an efficient drainage system, semicolon, river and stream rejuvenation, semicolon, preparation of a comprehensive drainage map, semicolon, restructuring of Guwahati drainage management system, semicolon, installation of pumping stations and rainwater collection ponds, semicolon, exploring the possibility of alternate drainage outlets, semicolon, more importantly, efforts and using modern techniques to trap soil runoff from the hills
adoption of an efficient garbage collection and disposal system, semicolon, promotion of rainwater harvesting system with perforated bottom drains and a combination of long, short and intermediate measures for immediate relief, like installation of sluice gates, at the mouth of the water bodies, upgrading the civic administration, civic administration, connecting of existing drains to the nearest natural drainage, scrapping and desiltation of the drainage, and installation of erection and setting up of some houses. Laying of storm water drain at appropriate place as also rainwater harvesting. Today, the Amicus has pointed out that if some legislative/regulatory measures are adopted by the state, the long-term efforts aimed at curing the problem would get a great boost. Some suggestions are that there should be a complete ban of building activities, at least for a couple of years. All hill cutting should be banned in Greater Guwahati. Reserve forests and hill areas be freed of encroachments, and projects for stormwater drainage arresting the surface runoff of the soil coupled with rejuvenation of water bodies would go a long way in controlling the problem. The Learned Advocate General without objecting to such suggestions, has pointed out that the state has taken up the matter in right earnest and has tried to address the issues both by a long-term sustainable plan as also short-term projects for removal of encroachment from forest areas and tightening of the implementation of the building bylaws. With respect to the drainage plan, the government invited tender for bringing in an expert body for consultancy services for preparation of GIS-based comprehensive drainage master plan and detailed project report for Guwahati city in the state of Assam. Pursuant to such an exercise, several expert bodies applied, and by a detailed and elaborate process, a Dutch company by the name of Asconing DHV Consulting Private Limited has been selected the agency referred to above has completed the detailed project report for the Bahini River Basin, and the government for implementing the project has sought to garner funds from the Asian Development Bank. First off, the proposed project cost is estimated at rupees 183 crores. The learned Advocate General has further informed this court that the project report referred to above has been accepted in principle by the Asian Development Bank and presently the Ministry of Housing and Urban Affairs, Government of India, is at the job of technical vetting and approval. To name some of the proposed major interventions, it has been pointed out that the project would involve diversion of stormwater from the Meghalaya catchment along the national highway to Pamohi River. Semicolon. The carrying capacity of Piney River would be enhanced by construction of retention walls and slope constructions. Semicolon. Creation of a retention pond with a provision for pumping water to Silsaco Beal. Semicolon. Quick evacuation of water from Rukmini Gaon by increasing the pumping capacity. Semicolon. Creation of additional drains at designated places. And preparation and creation of a silt trap at appropriate places for minimizing sediment deposition. In an effort to procure funds for the same, the government has also contacted the National Disaster Management Authority, which has promised help of approximately 200 crores for mitigation of floods across the Guwahati city. The learned AG has, however, very candidly pointed out that all these steps shall take some time to show its effect. For preparation of a sustained long-term drainage master plan, comma, a survey is being carried out by latest technology for an accurate and comprehensive data collection, which will take some time. The state is sanguine that with dedicated efforts at controlling these issues, with scientifically backed interventions across the state, and particularly Guwahati city, is definitely going to bring positive results. Positive results. We would require an updated status report on the projects said to have been initiated by the state towards this end by the next date. Let's list this matter in the month of, list this matter on so and so day in January.
Develop.
Not a few lines in my.
Oh, sorry. I just missed out.
It's okay.
उसको
Much
फिर
of
से
it.
लिख। उसके पहले। I'm so sorry. How did I miss? During the course of arguments, Mr. Das, learned advocate, has pointed out that one Gurukul Grammar Senior Secondary School situated near Zoo Narangi Road, Geeta Nagar, bracket Guwahati,
is now being converted into a multi-storied building. By cutting off neighboring hills. The exercise is dangerous for the residents at the foothills, as such reckless hill cutting could lead to landslide and collapse of the building in rainy season, or even by a mild tremor of any seismic seismic activity beneath the earth. He has further submitted that several representations were made to the authorities, but all such entreaties have fallen on deaf ears. Since Assam is prone to, it's Assam, since the state of Assam is earthquake prone, with around 25 earthquakes in the northeast region only in the month of March 2025. Such construction activity has to be controlled. And before that, it has to be verified whether the construction is being carried out after all the environmental and other clearances. The Learned Advocate General shall also look into this as aspect and shall submit a report in the updated affidavit regarding the status of the development, status of development, the status of carrying out the project for arresting the artificial flooding in the city. उसके बाद वाला वो लाइन एकदम
28/1, 28th January.
Yes.
Item number 4.
In this case, Lordship, by the last order, I was allowed to file a additional affidavit, which I have filed yesterday, but it may not be in the record.
I'm carrying copies, my lord. I thought it will not be on record, so I'm carrying copies. I'm just handing over, my lord. If my lord permits me. My lord,
Just a minute, let's see the last order.
my lord. We in fact see.
Today's okay.
There's an interesting irony, my lord, with the previous case. The earlier case
Can
pertained
we
to
just-
flooding. This is.
This is again taking a ground order. Just a minute, Mr. Fuken, we'll just go through our order.
My lord.
पोर्टेबल नहीं, पोर्टेबल करेक्शन में से पोर्टेबल होना है।
There are some typographical errors in the orders. See, a person who dictates, he cannot effectively proofread. So if you find some mistakes there, like, instead of portable, it is written portable.
My lord.
We would have missed on it. Yes, let us see the affidavit of the learned advocate.
No, before my lord goes to the affidavit, may I give the context on the of the I? We are concerned with an I.
Just a minute.
Well-
We'll take 2 minutes.
My lord, no difficult.
What is GMDA? What is GMDA? GMDA. Corporation का नहीं होगा ना, एक होता है। ये क्या है GMDA? लगता है कॉन्ट्रैक्ट। ये अच्छी सर in so then PMC क्या what PMC okay then PMC so relax PMC is run.
Yes, Mr. Pukan, are you asking us to do something for stepping up of the project, or are you seeking some kind of, intervention because you allege embezzlement of funds?
I am alleging, relying on the CAG's report, my lord. I am definitely trying to, my lord, make a submission
Now, what
for
do
your
you want?
lordship's concern.
Your primary intention is to find out the allegation of embezzlement of funds, or for stepping up the activity for preserving groundwater. Let's see this as,
Well,
whatever is important in your estimation.
My lord, my whole purpose of filing the PIL in 2021, my lord, was direction that all the projects, my lord, which were all conceived in 2009.
Yes.
There are 4 projects, my lord, which started in 2009. They had been hugely delayed. So my purpose was, my lord, that directions may be given for expeditiously completing
That's
all the
one.
projects. That's
So
one.
that's the main PIL.
That's the main PIL, my lord.
Right.
Now,
And now you say that the money which was allocated
Yes.
for this project,
Yes.
that has not been spent wisely.
Not just spent wisely.
We have softened it. We have
Yes.
softened it. the
Yes.
allegation.
And that has happened right under your lordship's gaze, my lord. When the PIL has been pending before your lordships, that is deeply troubling in my respectful submission. 2022, my lord, the CAG's report came, my lord. And if I may only be permitted to show a few paragraphs from the CAG's report, my lord.
Yes. It's part of this.
My lord, I've provided,
Just a minute.
my lord.
Yes.
I'll just read a few portions, my
You
lord,
have to-
just to save time, my lord.
You have to tell us the page number, no?
My lord, in my IA, if your lordship could come to page 68. No, this is IA number 3242 of 24. Because the report deals with a lot of irregularities and a lot of projects, I want to confine myself to what is before your lordship, my lord. And specifically, my lord, it's the South-West Guwahati project, water supply project. You know,
Yes,
the
68.
extracts start from 65, my lord. If your lordship could kindly come to 68, the second paragraph, second sentence.
Hmm.
My lord has it.
Yes.
Due to lack of monitoring by the project management consultant in respect of South Guwahati West Water Supply Project, 13,776.40 meters
we are
of
not
pipes
that
not
way.
laid by the contractor remain.
No, that's not the page that we are on. Highlights. Page 68 of the brief.
Well, Annexure A4 is the beginning of the report of the Comptroller and Auditor General. Lord.
Our report, it starts at page 65.
65, it's
66,
yes, that's right.
66.
Lord. Now, if your
And then
lordship
you're reading at page 68.
68, I'm reading, Lord, the paragraph, second paragraph that starts with an amount of 27.90 crores.
69. An amount of.
An amount.
All right. Yes.
I'm just straight away taking your lordship because this deals with multiple other projects also. I'm taking your lordship straight away to the second sentence. Due to lack of monitoring by the project management consultant in respect of South Guwahati West Water Supply Project, 13,776.40 meters of pipes not laid by contractor remain undetected, resulting in overpayment of 6.98 crore. Instead of engaging the consultant selected after observing procurement formalities, another firm was irregularly engaged November 21 as consultant by GMDA on nomination basis for managing the South Guwahati West Water Supply Project. I'll skip the rest. This again goes to a library and other irregularities. Let me now come to the bottom of the page.
Yes.
South Guwahati West Water Supply Project. My lord, has it? The last paragraph of the same page, my lord. The South Guwahati West Water Supply Project, which was to be completed in 30 months, September 2011, remained incomplete even after 11 years of start of the project, mainly due to defects in the DPR, non-completion of major components of the project, namely water treatment plant, semi-underground reservoirs, elevated service reservoir, pre-settlement tank, distribution grid lines, and intake well. More details have been given in the para which is indicated, Millard, here. I'll not take your lordship right now to that. The next paragraph, Millard, it was found that out of 1524.27 meter pipes to be laid by the contractor, only 1179.41 meter pipes of various diameter were laid by the contractor, resulting in less execution of 344.86 meter of pipes of various diameter. However, payment was made to contractor without verifying the actual execution of work, resulting in overpayment of 4.09 crore. Next para. Scrutiny of individual RA bills revealed that the up-to-date cumulative payment figure in RA bill number 78 was understated by rupees 3.22 crore in payment cleared up to the previous bill column in RA bill number 79, based on which the payment to the contractor was made till RA bill 135 and the contractor was paid 173.16 crore instead of allocated amount of 170.72 crore against procurement of DI and MS pipes, resulting in excess payment of 3.22 crore. Next parameter. 1.65 crore was regularly paid as interest to the contractor for delayed payment of bills, ignoring the additional conditions for payment mentioned in the general condition of contract, wherein it was clearly mentioned that after certification by the engineer, payment can be arranged within 28 days, but shall not be construed for any compensation in case of any delay beyond 28 days. So interest also was paid, Millard, to the contractor. The next paragraph. due to lack of monitoring by the CEO GMDA and lack of coordination between CEO GMDA and PD, unauthorized expenditure of 4.33 crore was done by MD Guwahati Jal Board for staff salary payments to vendors, etc., violating the agreement clause. Further, the payment made against the bills submitted by the contractor were neither certified by the PMC for JNNURM project, nor the bills were jointly signed by the CEO GMDA. Now, if your lordship may permit me to draw your lordship's attention to page 77. This is more on the irregularity aspect, my lord, but I'll just draw your lordship's attention to para 3, the clause somewhere in the middle of the page, my lord, page 77, 3.2.7.6, compliance of decisions taken by the authority. Apart from the inadequate human resources, my lords have it?
Yes.
Apart from the inadequate human resources to handle major projects, audit observed the GMDA was also unable to comply with important decisions taken in the authorities' meetings. A few instances are mentioned below. I'll just read this first serial number, Miller. In the 17th authority meeting held in June 2014 regarding water supply projects of Guwahati City, the authority noted with concern the tardy progress of the water supply projects of Guwahati City, and it was resolved that a detailed technical inquiry into the design, DPR, and implementation of the water supply projects will be conducted by the Chief Engineer, Public Health Engineering Department and the Assam Urban Water Supply and Sewerage Board. No step action taken by GMDA, the second column, Miller. No step was found to have been taken by GMDA for conducting the technical inquiry, and no inquiry into the design, DPR, and implementation of the water supply projects was conducted by the Chief Engineer, PHE, and AUW SSB. Remarked, the water supply projects undertaken by GMDA have been delayed by more than 11 years, which could have been addressed had GMDA initiated steps to conduct the technical inquiry and acted on the result of the inquiry in time. My lord, what I read from page 68 and 69 is more elaborately discussed in subsequent pages of the report. If your lordship wants me, my lord, I can take your lordship.
It's all right, you have understood.
My lord, the conclusions are there. Now, my lord, I would also like your lordships to notice one very vital
Let
document.
us see the recommendations also.
My lord.
At page 78.
My lord, page 78. GMDA should primarily focus on promoting and securing the developing of GMA according to master plan. The most important hazard of civic life in Guwahati, namely flash floods and traffic congestion,
Yes,
should
that's a different thing. That's not with respect
Yes.
to supply pipes.
A lot of
That recommendation is, we are taking care of that recommendation.
yes, a lot
Now,
of issues
we-
are
we
being
only-
clubbed.
yes.
Right. Now, Millard, I would like your lordship to also note one document which, Millard, I had filed with my affidavit in reply, Millard, in response to an affidavit in opposition of respondent number 5, Millard, and that is, Millard, a corruption inquiry which was initiated by them. In the main writ petition, Miller, they had filed an affidavit in opposition, to which I had filed an affidavit in response, Miller. That is number 5, respondent number 5. The lordship could have that for a moment, Miller. That is dated 16th of March 22, Miller. Page 32 of that, Miller. Page 32, Millard, of the affidavit in reply filed by the petitioner on 16th of March 22, Millard.
These long pending matters, Mr. Pukin, you should give me a separate pull-out.
I know.
Paging is not done properly.
Millard,
If
I
you have,
just,
give it to us. Read out.
I'll just read out. Annexure A5.
कहाँ से हम देखें?
Yes.
Millard, this is dated 4th February 22, my lord.
Yes.
My lord, order by the governor, in pursuance of government notification number so and so, and in the interest of public service, Sri so and so, Joint Secretary to Government of Assam, Personal and Administrative Reforms and Training Department is hereby deputed to assist Sri so and so who will inquire into the alleged complaint regarding corruption in JICA assisted Guwahati water supply project.
Affidavit in reply, is that right? Where are you reading from?
My lord, annexure A5/5, my lord.
I will not get it.
Page 32, internal page 32. My lord, it is actually of the PL, the affidavit in reply, my affidavit in reply.
Your affidavit in reply is with us, but paging. All right, this is Economic and Social Council. No, no.
No, my lord, that's not the one, my lord. My lord, the first annexure is a certificate of registration of societies, my lord, in that, along with that reply. This is affidavit in reply of R5, my lord.
Read from
My
there.
lord, may I just hand over the copy, my lord?
How will you read that?
My lord, it's a short, this thing, my lord. Your lordship, we just take note of it. 32.
What is with? What is? Yeah.
What is the full form of JICA?
It's a Japanese agency which has been, it's Japan International Cooperation Agency, if I'm not mistaken.
State program.
JICA assisted this whole, a lot of, not all the projects, but couple of projects are assisted by JICA,
Okay.
funded by JICA.
Let's now limit it to this. Now this, tell me one thing. What is, who is this? No, we'll be asking the Advocate General. This JICA assisted Southwest Water
Yes.
project.
Yeah.
Now, which is, what is Tahal Consultancy Engineering?
Tahal was a project management consultant, my lord.
Later, under the JICA.
It was appointed by the government, my lord, by the state government.
Appointed by the government, but in the same process when JICA was assisting.
JICA was, my lord, providing the funds, my lord, and government was overseeing the project through the PMC, the project management consultant, my lord. And a lot of detailed findings are also given in the CAG's report, which I will not bother your lordship with. But my submission today before your lordship is that what has the state done, my lord? These are on paper, it is a constitutional authority. The Comptroller and Auditor General has provided these findings, my lord. They themselves took note of this, my lord, in 22 when purportedly, my lord, an inquiry was started into corruption allegations. No, the affidavit is completely bereft of any details about what steps they have taken, my lord. And what is very shocking, my lord, as I said at the outset, my lord, all this has happened when this Honorable Court, my lord, has been monitoring this project, my lord. And numerous affidavits have been filed by them from time to time, my lord. So therefore, some stern, my lord, observations is all that I'm requesting, my lord, for the time being, so that, my lord, the project needs to get on track, my lord. With so much embezzlement, irregularities, my lord, on fundamental aspects of the project. And this is, my lord, a water supply project, my lord. 2009 it was conceived, my lord. 2009 to 11 the projects had started. In fact, there's a judgment of this Honorable Court of 2009 where your lordships took note of the problem pertaining to drinking water supply in the city of Guwahati, my lord. I filed that with the
That's
petition.
it, Mr. Saikia.
Yes.
A very sad state of affairs.
Absolutely not, Lordship. A positive thing is going on and a negative impression is been given. Now, how many of his own persons who have filed the case have taken the connection? Now the problem in Guwahati we are facing that out of 4 projects, all the 3 projects are running in full swing and people are not taking connections because they are illegally boring water from groundwater. Projects are already functioning. The positive thing is not being projected before the board. The thing is that it is very clear. In December 2024, South Guwahati Zone Jaiga project started fully functional. Southwest Guwahati Zone, which my learned friend was just saying, it is functioning from last year and fully functioning from April this year. We are now facing problem because not adequate number of persons.
Difficulty, Mr. Advocate General, is that your affidavit, it talks about the reasons for the delay.
Delay, yes.
But where is
Earlier, we have already filed the affidavit.
your file in it?
Yes. In fact, these questions were asked in the assembly. In assembly also, the replies were given.
Where is that affidavit?
Now they are totally diverting the issue.
Where is that
Yes,
affidavit?
I'll just give detail everything. Now Jalbird, who is running this, managing these water projects, they are now facing problem because adequate number of persons are not taking connection. Because we already had a parallel system also of Guwahati municipality.
What time to PIF? What about the other method?
Only out of 4, 1 is still to take off. Because
Give us the affidavit.
affidavit, Lordship, I'm giving because the accurate affidavit I have to submit. There are several affidavits from time to time.
Just find it out and we come back in 5 minutes.
Lordship.
We need a separate pullout. We can't find.
Or
from
if
here.
Lordship wants to take the matter on Monday, so that it will be more convenient for me because.
All right, Mr. Fuken, there is no problem for Monday.
My lord, I'll join through VC, my lord, with permit.
You've argued your part.
Lord, just on the connection part, my lord, I'll also show that there are minutes of meeting which permitted them to give the connections, my lord, and allow the consumers to
nothing.
pay in installments. I show that, my lord.
Regarding the access payment, everything has been reversed back to our. Now all the contractors are filing arbitration cases and my lord Justice D. Biswas is looking after the arbitration cases. Everything I will clarify. Because their whole case is that project is not taking off. We have done everything now. And this.
I think you're fresh. This additional affidavit takes note of other things.
Absolutely no issues.
No, this doesn't say anything.
He have to point out because he has trying to build up a case on the basis of the CAG's report of 2022. That is a routine exercise CAG has taken. And after that, lot of deliberations take place.
We just wanted to know that affidavit. Where has the project? What is the status of the project? What has happened? Have you been able to clock? I mean,
Yes.
Please make a note.
On Monday, Lordship, I'll give.
Please make a note.
I'll
what
give
we want.
note.
We want.
That is why they are not arguing that case.
We want.
That is why, because everything has been settled.
Now therefore we asked him that what is he interested in? Laying of
Lordship has
pipelines
rightly put that question.
or inquiry about the funds. Now, but you tell us, since it has been pointed out, you tell us. Just a minute, just a minute.
I'm sorry.
You have to tell us on Monday or any designated day, what efforts, what action have you taken against this Tahala?
Tahal.
Tahal.
Tahal is not the Gammon India is the problem. Gammon India. Tahal was a consulting agency. They have done the survey all across the
Execution is by Gammon.
Gammon India.
All right. So money to the contract. Have you been able to claw back that money?
Yes. In our affidavit, we have stated. In the latest affidavit also, we have stated. We have recovered the money. That's 7 crores.
Let me take it. I will not just adjourn it. We will keep it in November.
No difficulty, Lordship, because there is absolutely no case at all.
All right. No case at all, then we finish it. We close it tomorrow. You give it.
Monday, Lordship. There is absolutely no case at all. They are trying to rake up a old issue, that 2022 audit report. That is the first step.
That you said.
And what they have recommended finally, they wanted that these executive business rules of GMDS should be amended. That only we have not done. Rest we have already done.
We have heard.
In bits and pieces, they are showing few lines.
Mr. Hukin, learned advocate. We have heard Mr. A. Phukin, learned advocate for the appellant. For the petitioner and the learned advocate general. The case relates to non-completion of the south, what is that project?
South Guwahati West Water Supply Project.
Project of
South
South
Guwahati West.
South Guwahati West.
Southwest Guwahati zone,
That is happening.
Southwest.
Southwest Guwahati.
What have I said? Non-completion of the project in order to preserve the groundwater and provide potable water to the citizens. Mr. Phukin has pointed out from the audit report that there had been embezzlement of funds, and he suggests that that is one of the reasons for the delayed completion of project. Just upon the contrary, the learned advocate general has submitted that the CAG report was of 2022, which was done in a routine manner, and whatever was pointed out has now been rectified. The excess money paid to the contractor has been clawed back, and most of the projects have now become functional. The difficulty now lies with the citizen of Guwahati who are not very willing to use potable water supplied through pipelines. Rather, they are content with their private borings in their houses for recovering groundwater. He further submits that whatever deficiency was pointed out in the CAG report, in the audit report, has now been rectified and necessary action has been taken. He submits that on the next date, he shall point out in detail regarding action taken against the erring contractor and the status of the project as on date. List this matter for further consideration.
Would my lord also like to mention that 4th February 22 order, which I pointed out, where they themselves initiate an inquiry, my lord.
That's right. So we have said
That inquiry, we ourselves is initiated in 2023, long time back, not before this
in all these PILs, the request is to keep a pull-out of the affidavits which you would want to us to read.
If a short date is given, then the memory will be fresh, lordships also. Next week.
And next week?
Yes. Because it will hardly take 5 minutes. I'll just point out.
Next week in November.
If it is difficult, then lordship, let it be.
November, I am in Aizawl.
No difficulty, lordship.
So we will put it sometimes. November. What day in November? We keep it on a Friday. On 21st of November. 21st. Again. Okay. 28th of November. 28th of November.
Lordship. Could it be 24th, my lord? I'm here, my lord, subject to convenience, of course. 24th November, could it be, my lord?
24th. 25th, if you are here, we can keep it on 25th.
Or any date. 25th is also fine. Yes.
25th of November. We come back. There are certain eviction matters you have to
That
be
is
here.
there, and that school matter is also there.
We will try and complete it. Let's see. These two PILs took a lot of time.
Yes, Lord.
But these are important ones. These concerns so many.
So far, this is a stale one, the present one, which lordship has. It has spent his force. But the other case, lordship, we are definitely, that's why I requested lordship's monitoring, so that we are also not.
Yes. That we understand that you are at it. We'll come back in fact.
Item number 5,
May it please, your lordship. Okay, appear for the respondent 1 and 2, your lordship. You will be filing the objection by next week, your lordship, as you have sent it for approval of the same, your lordship.
The learned advocate, correspondent number 1 and 2, submits that by the next date, the response affidavit shall be filed. For the aforesaid purpose, a short adjournment is sought for. So pre-notify on. Give a date in November.
24th November.
Oblige, deeply oblige.
Item number 6.
May the lordship. As per official, the lordship, we may be direct to take steps, Dusty, on the respondent number 5, your lordship.
Awaiting the service of notice on respond number 5, the matter is adjourned to January.
Oblige, your lordship.
This is the same case where respond number 5 has not been appearing even in the writ.
Yes,
petition,
Lord.
he did not appear.
Yes,
Is that the same?
Yes, your lordship.
Then we will hear in his absence.
We'll
The next-
try to take like Dusty, your lordship.
Dusty or remind us on that day, we will say that.
Yes, your lordship.
Or we'll issue court notice or do something.
Much
Let's
oblige,
see.
your lordship.
Let's see.
7 January.
May I please, my lord?
Item.
Item 7. Item 7.
7 years.
Now, this has to be listed along with that PIL, where I have
PIL
requested the Advocate General to look.
51/2025. Sorry, 47/2025. And Lordship was pleased to pick the matter on 16th December.
All right, let this matter be listed along with
I think.
PIL number 47 of 2025, which is slated to be listed on
16th of December.
on December.
16. Deeply obliged.
Item 8 to 26.
My learned friend is not here, Lord.
No, this we can't adjourn beyond.
My learned strong friend.
Can I-
Before I start, your lordship, I have prepared a. Indeed.
Yes. You are leading the arguments on behalf of all.
I'm appearing in 8 cases, your lordship, from item number 10 to 18.
All right, who appears in the other cases?
8 and 9.
Senior counsel, as a.
Yes.
Mr. S.
I leave from his lordship.
Mr.
He was
Bhatta-
sitting-
Yes.
Land-
Yes, sir.
Your lordship, may kindly peruse the land policy for a moment. Land policy.
Yes.
Clause 14, your lordship, settlement and reservation of land in towns.
New or old? Land.
Land policy 2019, your lordship.
Clause 14.
14, your lordship, settlement and reservation of lands in towns. 14.2. As your lordship, got it, 14.2, your lordship. An indigenous person who has no homestead land in his name or in the name of his family in the state may be eligible to get land in Guwahati city or in the urban areas, provided that such person is required to reside in Guwahati city or in that urban area by very nature of his occupation service, provided further that he has sufficient ground to justify that he has not been able to purchase land in Guwahati city, other towns. The state government will not consider settlement of any government land to Guwahati city or in other town areas under possession of individual or other persons merely on the ground that the person concerned is in occupation of such land, irrespective of the period of such occupation or encroachment. It will be the policy of the state government to consider settlement or evict such persons as the case may be. 14.4, however, in view of the land policy 1989 and other government decisions prior to adoption of this land policy, the cases of indigenous landless person, if found eligible.
To speed, you don't have to speed up like this, no?
I'm sorry.
It's faster than what I'm reading.
Yeah, sorry.
It's-
I tried. However, in view of the land policy 1989 and other government decisions prior to adoption of this land policy, the cases of indigenous landless person, if
found eligible and who have been made under continuous occupation of government land since or prior to 28 June 2001 may be considered for settlement of maximum of 1 katha 5 leases of land in case of Guwahati and 1 katha 10 leases of land in case of other towns as one-time measure for homestead purpose if they apply for it, irrespective of having an land in rural areas subject to realization of due premium. So, Your Lordship, there is a provision for providing land of 1 katha 10 lesser. Now, Your Lordship may kindly peruse for a moment the Assam Land Revenue Manual.
That is the. So if you're referring to all this, we are. Only one.
Only one, regulation 12, Your Lordship. Only regulation 12, and then I will come to the judgments, Your Lordship.
No, I was on another thing. If you're referring to this, we know about this
Yes, Your Lordship.
rule
Yes,
that land can be settled, but it cannot be a grazing land, it cannot be a hospital
Yes.
land, it cannot be other lands.
Very true.
I mean, that we know that.
Then Your
Now,
Lordship may.
in 3 months' time, I have come to know about the land policy of the state of Assam. But still, you show it to us.
Yes, sir. Well, Regulation 11, Your Lordship. No, Regulation 12, sorry.
Number, your case is 10 to
10 to
18.
18, Your Lordship.
which provision? Assam Land and Revenue Regulator.
12, Your Lordship.
Okay.
Regulation 12, Your Lordship.
If you're having the same publication, you can tell us the page number.
Page number is 38.
38.
38 in my page.
Oh, that's a different book.
Oh,
That is power to make rules.
the power to make rules for
So
disposal
you
of
will now
government.
go to the settlement rule.
Yes, Your Lordship.
Come to straight to settlement rule.
Yes, Your Lordship.
Power to make rules for allotment of grazing ground. Power to make rules for disposal of government land and adjustment therefore from unauthorized. Where are the settlement rules?
The settlement rules, Your Lordship, I'm relying on Rule 13A,
This space,
No, he doesn't
page
have that.
143.
no, it is here only. In this book only,
Yes, Your Lordship.
settlement rules.
Yes, Your Lordship.
Anyway, you read from that.
Yes, Your Lordship. 15, settlement of occupied lands not included in any lease. No person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the
Just-
state government.
They will please
Yes.
don't flow. Just a minute, later.
Rules under the Assam Land Settlement Rule. Yes. Which provision? of
15, Your
settlement?
Lordship. 15.
15.
Yes, Your Lordship.
Settlement of occupied lands not included
Including
in
any
lease.
state, Your
Yes.
Lordship.
What does it
No
say?
person shall have any right to settlement merely because he is in occupation of land not including any lease granted by the state government either to himself or to any other person. Now, Your Lordship may kindly peruse the land policy 2019 again for a moment, Your Lordship, 15.1 and 15.2.
Hmm.
15.1, Your Lordship.
Hmm.
Deputy Commissioners shall regularly obtain detailed report on encroachment over government land, including reserved land and land acquired under various land sealing acts, and take appropriate and effective steps to evict those encroachers who are not eligible to get settlement of land as per land policy of the government. 15.2, Your Lordship, is very important. Deputy Commissioners shall prepare a scheme plan for eviction of every district as per instructions issued by the government. Such scheme should also include post-eviction plan. Now, in this case, your lordship, we are on settlement because we do not have a bona fide right to claim. It's an admitted fact that all the appellants have been residing in government land from the last more than 30 years, your lordship. So we do not have a bona fide right of claim, but the post-eviction plan is not there. Your lordship may kindly peruse the citations that I have, the compilation, your lordship may kindly peruse page. Page 32, your lordship. I'm relying on Olga Tillis, your lordship is away. I'm relying on Olga Tillis, this is a constitutional bench judgment, your lordship. At page 32 of the compilation, your lordship. I'm relying on paragraph number 49 and 51. May I read, your lordship?
This is Olga Tellis.
Yes, it's Olga Tillis. These are the slum dwellers of Bombay, your lordship. May I read, your lordship? The jurisprudence requiring hearing to be given to those who have encroached on pavements and other public properties evoked a sharp response from the respondents' counsel. Hearing to be given to trespassers who have encroached on public properties. To persons who commit crimes, they seem to ask in wonderment. There is no doubt that the petitioners may. Sorry, Your Lordship. There is no doubt that the petitioners are using pavements and other public properties for an unauthorized purpose, but their intention or object in doing so is not to commit an offense or intimidate, insult, or annoy any person, which is the gist of the offense of criminal trespass under section 441 of the Penal Code. They manage to find a habitat in places which are mostly filthy or marshy out of sheer helplessness. It is not as if they have a free choice to exercise as to whether to commit an encroachment, and if so, where. The encroachment committed by these persons are involuntary acts in the sense that those acts are compelled by the inevitable circumstances and are guided by choice. Trespass is a tort, but even the law of torts requires that though a trespasser may be evicted forcibly, the force used must be so greater than what is reasonable.
That's right. So therefore, the 49 and 51 read together.
Yes, Your Lordship.
It only says that pavement dweller have to be evicted. No difficulty.
Yes, Your Lordship.
But they must be asked question why. It is not a matter of choice because they are poor, they are pavement dwellers.
Yes, Your Lordship.
But then they have to be removed.
Yes.
You are talking about post-eviction plan of settlement.
Exactly, Your Lordship.
Now,
Para
that we
50
understand.
Para 51, Your Lordship, from 14th line from the bottom, Your Lordship. May I read, Your Lordship? It starts with the word we are. We are of the opinion that the petitioners should not be evicted from the pavements, footpaths, or accessory roads until 1 month after the conclusion of the current monsoon season. That is to say, until October 31, 1985.
That's guided by this dictum of the Supreme Court. This observation, not dictum, this observation of the Supreme Court. We gave time till Diwali.
Exactly.
Did we or did we not?
Yes, Your Lordship, but Your Lordship may kindly.
With no coercive step order. That we did. Now you have the only ground that you have is there must be some post-eviction
plan, Your
plan,
Lordship.
right?
Yes, Your Lordship.
So you close your argument on that.
No, Your Lordship, there are other judgments that I would like to cite.
Judgment's all right, but issue is this.
Yes, Your Lordship.
Eviction, you can't, you don't have a right to be on a particular pavement or reserved forest area.
True, Your Lordship.
But there has to be some plan.
Yes, Your Lordship.
So that plan for how long? This was with respect to census of 1976.
Yes, Your Lordship.
How long? Suppose stealthily you acquire some plot of land, you start residing in a reserved forest area. From there, you carry on your commercial activity in some way or the other. Your son, your grandson, all of them start living there. And you want a land from the government because welfare estate the government has to do.
Yes.
But then some inquiry has to be made. Not every landless has to be given land. Yes. What are the judgments? In principle, it is the same thing.
Principle
So
the
we'll
same.
ask them about the post-eviction scheme. We'll ask them about post-eviction scheme. That's one big ground that you have posed before us. Anything else that you want to show?
Your Lordship, I'm relying on a judgment of the Delhi High Court, Sudama Singh versus Delhi, page number 72. It started page number 72, Your Lordship.
72.
Division bench of the
Yes.
single bench, Your Lordship.
Yes, which paragraph?
Para 26, Your Lordship, page 79, right to shelter. Down below, Your Lordship, page 79. That's page 70 79, Your Lordship. Right to shelter.
Yes,
The housing. The housing problem can be considered to be universal since to date, no country has yet managed to completely meet this basic human need. Adequate housing serves as a crucible for human well-being and development, bringing together elements related to ecology, sustained and sustainable development. It also serves as the basic unit of human settlements and as an inspector of the duality of life of a city or country evidence. It reflects, among other things, the mobilization of resources and the distribution of space, as well as varied social and organizational aspects of the relationship between government and society. Unfortunately, in spite of its importance, there exists an enormous housing deficit throughout the world. Even the United Nations, more than 1 billion people are living in precarious shelter conditions, including those who are homeless. Now, I'm not reading the other paragraphs, Your Lordship. I'm straight away coming to paragraph 54.
yes.
In order to ensure the protection of human right to the highest attainable standard of physical and mental health, all affected persons who are wounded and sick, as well as those with disabilities, should receive the medical care and attention they require to the fullest extent practicable and with the least possible delay, without distinction of any non-medically relevant grounds. When necessary, affected persons.
You're not asking for this. Now tell us about location, relocation.
Yes, Your Lordship. Para 56, Your Lordship. May I read, Your Lordship? In determining the compatibility of resettlement with the present guidelines, states should ensure that in the context of any case of resettlement, the following criteria are adhered to. No resettlement shall be take place until such time as the comprehensive resettlement policy consistent with the present guidelines and internationally recognized human rights principle is in place. Resettlement must ensure that the human rights of women, children, indigenous people, and other vulnerable groups are equally protected, including their right to property ownership and access to resources. The actor proposing and or carrying out a resettlement shall be required by law to pay for any associated costs, including all resettlement costs. Now, perhaps 57, Your Lordship. Rehabilitation policies must include programs designed for women and marginalized and vulnerable groups to ensure their equal and enjoyment of the human rights to housing, food, water, health, education, work, security of the person, security of the home,
Yes,
freedom.
follow.
Then para 37, Your Lordship. This is the next page 12, Your Lordship, page 83.
No. Decent living, Article 21. That's right.
Yes, sir.
That's right.
So in 37 in Catena of Decisions, page 83, Your Lordship.
Okay, we have seen that.
Yes, Your Lordship.
No animal-like existence.
Yes, Your Lordship.
That is again, when you're relocated or you're resettled.
Yes, Your Lordship.
That's it.
Page 90, Your Lordship, may kindly page 54. This is the decision of the Constitutional Court of South Africa, Your Lordship. In the case of residents of Zoslovo community, Western Cape versus Tulesiva Homes and others, the Constitutional Court held any government decision taken and consequent order made regarding the forced eviction of a group of people cannot ignore the enormous impact that a potential forced removal will have on the individual, family, and community at large. No matter how commendable the government intentions are regarding the intended use of the land from which the community has been removed, without the solid promise of alternative housing, evictions may turn out to be method of brutal state control and a far cry from the progressive realities.
That, Mr. Deori, the argument therefore should be that there is no policy in place for relocation in terms of the paragraphs that you have read. That's all.
In fact, the master plan.
Read one very important line, that no resettlement, no relocation until a policy is framed.
Exactly.
And perhaps your argument is that in the land policy, I mean, it is inherent in the land policy, but there is no specific scheme
Exactly.
for relocation.
Exactly. And the Guwahati Master Plan to 2025, Your Lordship. Guwahati Master Plan, 2025. I have marked this Guwahati Master Plan 2025 Part 1 and Part 2, Your Lordship. I'm only point out 8.4.3 in Part 1. 8.4.3, Your Lordship. 8.4.2 and 4.3.
Part one.
It's tag, Your Lordship. In Part 1, it's tag 8.4.2 and 8.4.3. In 8.4.3, Your Lordship, had Your Lordship got it?
Yes,
In the right-hand side, Your Lordship, the second part, in the middle, other slum pockets may be resettled for at appropriate areas with due consideration of their distance from workplaces. Your Lordship. In the right-hand side, Your Lordship.
one percent reserved for.
Yes, Your Lordship. Develop for informal sector vendor markets which should be available to urban. Such a land can be for informal sector units in food, vegetable eating stalls. In fact, it also provides, Your Lordship, in the last part of the land shall be developed for night shelter where fresh migrants to the city having no shelter could be provided with facility to help sleep and have sanitation and basic facilities. Now, Your Lordship, may kindly produce the Part 2. Part 2, 14.7, Your Lordship. Slums upgradations resettlement.
14.7.
14.7 units. Slums
Yes.
are scattered in different parts of the city. Slums upgradation resettlement shall be taken up for these slum areas. So there is a
That's what you don't like. You don't want to be placed in a slum. This is where the slum exists, how it is to be upgraded.
yes, Your Lordship.
You
But-
want resettlement.
Yes, Your Lordship. My respectful submission is there are places where they can resettle us. They have not resettled us. If we are evicted, we have no other place to go, Your Lordship.
Where are those facts? That's why I've asked that you are a landless person, you don't have land, you have applied for settlement that has been rejected or pending.
Where is
These are principle of law, isn't it?
Yes,
You
sir.
must come into those categories. Where are those factual material?
Petitions are there. Your Lordship. I can trace.
No, no.
That's why I on the first.
No, tell me one thing. There must be a forum where you have to apply.
Yes, we have applied.
So what has happened there?
It was rejected, not
Why?
considered.
Why was it rejected?
It was not considered, Your Lordship. We
No, no,
applied-
non-consideration or consideration considered and rejected.
No, we applied.
Have
Your
you challenged that?
No, Your Lordship.
So therefore, where do you fit in here?
We
In
were-
Article 226.
No, Your Lordship, we were living in a government land, Your Lordship. We applied for.
That's right.
for
So you
settlement.
applied for lease. You
Yes.
applied for that Miadi Patta.
Yes, Your Lordship.
Whatever. So that was rejected.
Yes, Your Lordship. So my only respectful submission is, Your Lordship, we are ready to move away, Your
They
Lordship.
must, they must have given you some reason that there is no proof that you don't have any land, you're a new migrant and all that.
No, no.
Now you would have asked for being settled in the same land where you're staying.
Yes, Your Lordship.
So that it has to be rejected. No reason whatsoever. For the reason that it is reserved for hospital, I suppose.
True, Your Lordship.
Or can we change it?
No, Your Lordship, I'm only on the point that I may, the families, Your Lordship, may be resettled in some other area, Your Lordship. That is my only
That's
respectful
right.
submission.
So
We do
for
not
that
have
also
enough-
you have to make an application, no? Can it be decided on the basis of Olga Tellis straight away? Olga Tellis tells us that we must ensure that the government makes a plan for relocation. Then Sudama, as you read from Delhi, there must be even a post-eviction plan.
Yes, Your Lordship.
So that plan, do you allege that there is no plan of the state government?
No, Your Lordship, in my respectful submission, no.
And what is this resettlement thing?
This is only with respect to the plan, Your Lordship, master plan of Guwahati. And the land policy
This
2019.
plan, no.
Yes, Your Lordship.
So where is there any forum to apply for getting resettled, for being provided land for you to settle, take your family there, have a shelter? There must be some body here.
I am not sure, Your Lordship. I don't have any.
Anyway, that's it. You close your case at this, we will
Yes.
consider. Yes, Mr. Datta?
If the particular facts, this is what time pass. Individual.
Definitely, Your Lordship.
Yes, in each of the case, you have to give a fact sheet.
Exactly.
You know what fact sheet is?
Yes, Your Lordship.
With respect to that particular petitioner.
Yes, Your Lordship.
Give it by next Monday.
Yes, Your Lordship. Definitely.
You have done lots of work. See, we can see, Mr. Deori, you have procured this master plan for Guwahati, you have flagged it well, and I'm particularly happy with the way in which you have given us the compilation.
Yes.
This is for the comfort of the bench, we understand, but then it's easier for you to argue. All right. Yes, Mr. Datta?
Deeply obliged.
Last.
Yes.
From
10 to 18.
10 to 18. 10 to 18. Yes, it's open.
10 to 18 collect kar
जी.
I have submitted my written argument, madam.
Yes, Lord.
Copy did I?
File input. Yes, no. Yes, no, you must. Yes.
Lordship, kindly.
You are appearing in which matter, Mr. Chaudhary?
I am item number 8, my lord.
You are in
What?
item number
Yes,
8.
my lord. My humble submission before
The
your
first of the matters. And then Chaudhary wala. Huh? And then
this will be fine.
there's no problem. Well, in continuing, we can sit here for another 15-20 minutes.
I can argue.
I,
My lord, my humble submission before your lordship is there. My argument, first argument is
yes.
if your lordship want to take.
No, I'm asking you.
Yes,
We are not hungry.
sir.
It's
Yes,
it's
sir.
for you. You have to stand and talk.
No. My humble submission before your lordship is that when there is a, my lord, report from the Mondal and other, in respect of other case, whether there, what happened in this instance case, my lord, my whole case's argument is that DAG number 97 does not belong to the TB hospital. Subsequently, it was said, nomenclature has been said as part of the school medical college. I argued, your lordship kindly go to my petition, additional affidavit. Thereafter, my lord, affidavit in opposition, they file, I file reply. Nowhere they stated that DAG number 97 is belong to the TB hospital. I'm coming, my lord. Subsequently, what happened? They developed their case, my lord. I saw your lordship, my lord. And there are 2-3 persons, my lord, where settlement has been given, my lord. And one mainly I am arguing, 2 person has been, they said, before filing of the case, that we are going to cancel their settlement, proposal has been, and 2 persons, Madan Mohan Biswas settlement has been given. When either Arun Kumar Singh or Bankim Chandra Biswas, Madan Kumar Biswas, when settlement has been given, there is a report called from the Mondal, subsequently it was circle officer has opined, deputy commissioner has opined, the land is not belong to the TB hospital. And there is a minutes of the meeting in 2022, my lord, where categorically my land DAG number 97 was DAG number 997 was not mentioned, where in 447. Subsequently, at the midst of in my affidavit in reply in respect of Bankim Chandra Biswas, Madam Chandra Biswas, they never said that this was erroneously made. Then at the last stage of argument, I have to submit before your lordship, whether they are submitting same circle officer has filed them, my lord. affidavit officer. Last time, one word has been said, so that erroneously there has been made, my lord. And settlement has been made to them, my lord. Then they made an, my lord, submission before the honorable court. They are going to, my lord, cancel all the person's settlement, my lord. Interesting thing is that what is they have argued, either Bankim Chandra Biswas or Madan Mohan Biswas, till today no proposal has been sent, no decision has been taken to cancel their, my lord, Patta, my lord. And we are issued eviction notice. Second, my argument, man. I can show all this thing, my lord. First, in a nutshell, I started my argument, my lord. Second important thing is that, my lord, that there is a judgment by Honorable Justice, my lord, the what's it, 3715, that 6 point has been mentioned, 5 point has been mentioned. One of the point is that the deputy commissioner shall pass the order, my lord. Here in the instance, they can, my lord, as per land and revenue regulation, they can, my lord, delegated the power. But what happened in the instant case? First, we have submitted representation to the deputy commissioner, my lord. Then deputy commissioner sent it to the co-district commissioner, my lord. And what happened? Co-district commissioner, here the petitioner, although we filed the representation, nothing has been discussed in the speaking order about my lord representation. What happened? I have categorically stated they take the statement. There are some statement in the vernacular. Some people are not known this vernacular land, although they are indigenous people as per policy of land and revenue regulation. 35, if there says 35 years and 3 generation, they are 30, they are indigenous people. But what happened, my lord, in the instant case, my lord, after hearing the matter by the co-district commissioner, deputy commissioner has passed speaking order without submitting the, without giving the report to the all the, my lord, claimant, my lord. And speaking order, if your lordship go to the speaking order, and if you go to the representation, my representative, nothing has been discussed. And one cases, my lord, same dag number, the Pulmoni Talukdar, I had given that order. That said, as per this the decision of this honorable court, that circle officer has no power to issue eviction order. Same mistake has been done here also, my lord. Circle officer has issued the eviction notice, my lord, to evict the person from the place of land. Now, your lordship, and one side, there's a report of circle officer, and my lord, on the basis of that, deputy commissioner has said, and as per land advisory committee, stated that this land, like number 97, not belongs to the circle. And other hand, they have given some copy of the Malasita, where record existed on 3 years made a comment that this land is a circle land. Interesting, another argument I developed in the single branch file, but that was not discussed, Honorable Single there, that if they have said that land is belongs to TB hospital, if the land is belong to the TB hospital, my lord, then Assam Public Premises Eviction Act will follow. But nothing has been discussed there. In my pleading case also there, my lord. This is in nutshell my case, my lord. I want to show some document, my lord, as already I am given the written, my lord, statement. Lordship, kindly come to the, my lord, minutes of the meeting, 449. This is the minutes of the meeting, my lord. Annex I have 449. Have you lordship got it?
Yes.
Minutes of the meeting held on 19/2/2022 in the conference hall of the Deputy Commissioner, Kamrun Metropolitan District, regarding allotment of land with second medical college. List of member present. The meeting was presided over by so-and-so, Deputy Commissioner, Kamrun Metropolitan on 19/2/2000 in the conference hall, office of the Deputy Kamrun Metropolitan District at 4 p.m. regarding the allotment of land second medical college at Guwahati. After threadbare discussion, the following decision was taken. First, The member of the meeting discuss about the urgent need of a second medical college for better health, Assessor General. The nomenclature, third, that is important. Allotment proposal land measuring 5.75 per 4 acre covered by the DAG number 90 of village Moja is approved by the Special Division Land Advisory Committee subject to acquiring NOC from Animal Husbandry and Veterinary Department. Allotment proposal government land 12.30 DAG number 90 at village Ulubori Moja in the approved. Allotment proposal measuring 51.3 covered by DAG number 2 Ulubari Moja is approved by subject to NOC from Animal Husbandry Department. DAG number 97 not mentioned. In other way, Arun বিশ্বাস was. On the other way, my lord, 344, your lordship kindly come.
Other page?
344, my lord. T1 2022, my lord. Regarding settlement of land in Arun Kumar Singh, Ramananda Singh, with reference letter number subject cited above. I have to honor here with the report submitted by the circle officer. Has your lordship got it? Second line. Guwahati Revenue Circle. High letter number so and so. Dated 22/12/2021. In connection with settlement of land measuring 0 biga 1 kotha covered by DAG number 97. Because the argument of the government is that the whole 36 biga land belongs to TB Hospital, madam. Village Ulubari, under Ulubari Moja in favor of Arun Kumar Singh. It can be noted that proposed land is not allotted for settlement in the name of TB Hospital as per land record available. On the basis of record, that statement has been made, my lord. And the proposal was approved by SDL.
Mr. Advocate General, you have to take note of this.
This was a mistake and we have rectified and the correct position was placed with record before the ordinance.
No, may submit my lord. My landed sorry, Advocate General is not appearing. He is appearing, my lord. Record is not produced before the court, my lord.
The part of the affidavit I have just shown me.
Yes. Sir.
We have requested the Advocate General to be here because it concerns landless people
Yes, sir.
and the state action of eviction.
Yes, ma'am.
Therefore, we have asked it.
Yes, ma'am. And another thing is that just your lordship is asking Mr. Deuri. In my petition, I have categorically stated that I am a landless people. I applied for the Kobula, my lord. And Kobula, this should be, my lord, this is my bona fide claim, my lord. And bona fide claim has to be, my lord, my lord, disposed of by the authority, my lord, with proper application of mine, my lord. That is why I am submitting all these things. I am coming later on, my lord. First, I want to show this one. Resolution to then compliance of the Honorable High Court order, so and so. Then your lordship kindly come to the, my lord. Patta has been issued to the Madan Mohan Biswas, my lord. After verifying all these things, report of the SDLC, circle officer report on the basis of record available, circle officer, my lord, my humble submission is not given this report, my lord. He has the competent officer, is ACS officer, deputy is IS officer, they are competent person, my lord. After verifying the record, they have given report. That is my understanding of my lord. Law. And my lord, right of the inheritance, then your lordship, Patta has been given. Madan Mohan Biswas, Bankim Chandra Biswas. As per my knowledge goes, as per my lord, as per my instruction, no notice has been issued to the Madan Mohan Biswas, Bankim Chandra Biswas, evict from the land, my lord. And Arun Kumar Singh, no notice has been issued by them. Now, in respect of my bona fide claim over the land, my lord, I have stated in my point number 3 of my argument, my lord. Under Rule 18.2, Assam Land and Revenue Regulation, Deputy Commissioner has got the power for ejectment and give settlement of the land, my lord. Rule 15, already my Deuri has submitted. There should be a bank, my lord, in respect of government land, my lord, which has been possessed and which are not possessed. I have not argued on that point. That point of the, my lord. Your lordship kindly come to rule 18.2, my lord.
Six, it's, is,
120. Delicate, no?
rule 18,
Yes, ma'am.
rule 18. Okay.
I directly come to the deputy commissioner, 18.1. Subject here provided the deputy commissioner may eject any person from the land over which no person has acquired the right of proprietor, landholder, settlement holder. When such person has entered into the possession of government land, wasteland, so and so, he may eject, order to vacate forthwith, and the deputy commissioner may shall consider destroy the crop, raise any building without any authority of the land. Now, your lordship kindly come to the delegated power, my lord. T.
Yes.
Delegation of power of deputy commissioner. The deputy commissioner may by general or special order, there must be some order, my lord, delegate to the revenue officer within district or all the power conferred by this rule, including the power to receive application of land provided no officer lower than status than sub-deputy collector shall pass final order, issue periodic list to grant settlement, and provided sub-deputy collector may not exercise such power if the land question will be a delegation rule 1802 may be made only subdivision officer or to a circle officer or circle officer attached. Now, your lordship, what happened in this case, my lord? When argument has been made before the language single judge, there is an order that deputy commissioner shall pass the eviction order. Your lordship kindly come to the judgment. I, in my petition, my lord, I have annexed same, my lord, tag number 98, my lord. এইটো নহয় মই যিটো কৈছিলো সুৰেশ চৌহান $559 মাইলৰ মই কিবা কিবি কৈ থাকা তুমি চিন্তু মই জানে নাই সুৰেশ চৌহান Last demand.
549.
Yes, my lord. Sorry, my lord, this is public premises eviction. 559, my lord. Sorry, my lord. 559, my lord. Your lordship kindly come to the, my lord. Next page, my lord. Para 4. As regard the, here, my lord, notice has been issued by the circle officer. As regard the impugned notice, it has been submitted that circle officer Guwahati would not be competent authority to issue the same, which is clear with the court judgment order dated 7/11/2024. That order I will come later on, my lord. In that order, para number 5, thing, 340. I'll come later on. That deputy commissioner has got that power. Then your lordship come, my lord. Shri Barpujari Land Standing Council Revenue Department while disputing the other side on behalf of the regarding a claim that land is question not preserved as fairly considered that notice by the circle officer do not appear strict compliance with the direction of this court. He, however, hasn't, there is a no prejudice cause to this, so and so, so and so. Accordingly, last part, my lord, page 8, that judgment has been discussed here, my lord. Para 6, my lord. To appreciate rival submission necessary 711 with regard as follows. The impugn notice rule so as to petition I have to vacate the shall be constituted Guwahati Revenue Circle. So cause I am directly coming to the Mala para 4 and 5. The Deputy Commissioner Kamrup is direct to give an opportunity hearing petitioner personnel through the authorized officer representative. The Deputy Commissioner Kamrup shall thereupon appropriate speaking order. That appropriate speaking order necessary. The Deputy Kamrup is further direct to allow the particular area in the office has reply and notices be hanging. Deputy Commissioner Kamrup Metro. This goes further direct that upon speaking order being passed, the Deputy Commissioner Kamrup may shall notify in notice board about the fact of the speaking on the past for a period of 30 days, such no coercive action be taken as agreed. It appeared that the 711 had directed Kopita to give an opportunity of hearing. The impugn notice, however, not issued to the deputy but the circle officer. Same thing has been happened. This could therefore opinion without making any comment intercede the real matter on the ground. Notice have been issued by the was not mentioned direction of the court 711 notice. The accordingly the petition is allowed and accordingly, my lord, it is however made clear only on the ground circle should no bar for authority name order the 711 to action in accordance with law. Lordships know very well. They have a power. As per book, there is a power, my lord. In whole hearing, my lord, if your lordship go to the affidavit, there is no document has been produced to show that deputy commissioner has delegated this power to the circular. Piecemeal basis has been what is done, my lord. One person heard the matter, one person submit report, and that report was not given to the petitioner. This is highly audible department and pass the speaking order. If your lordship go to the speaking order and my representation, nothing has been reflected what I argued, my lord, what I am submitting in my representation, my lord.
Sir, Chaudhary,
Yes.
what is the order based on which you have been issued the subsequent order?
My lord.
That is important.
Yes, my lord. Oh, yes, my lord. Lord. Lordship kindly come to the my lord. The judgment itself, my lord. From the minute judgment is going to start, okay? That's all.
Very well, Mr. Chaudhary. You seem to have lot many missiles in your arsenal. You will not be ending before 1:30. So we come back after lunch.
Yes.
We'll come back after lunch. The other advocates also, Mr. AG.
Yes,
is
yes.
required. Mr. Datta, you can also come back thereafter. 15 minutes you end your hour.
Yes, ma'am. Yes, ma'am. What is going on?
Yes, Mr. Chaudhary,
Yes,
continue.
my lord. As Honorable Justice Chaudhary has asked, the process has been initiated under which notice?
Yes.
Your lordship will find page 249. On the basis of that notice, process has been started, my lord. Second time, my lord. After the judgment has been passed by Honorable Justice, it's case number 2, D. Borua, my lord, this process has been initiated, my lord. It is informed you through this notice that as per order passed 3715, passed by the Honorable Guwahati High Court order, and memo number so and so dated 26 by Deputy, you are informed to vacate land within 30/4/2025, which is occupying illegally government land belonging to the TB hospital, covered by DAG number 97 village under Ulubari, Mauza Ulubari. Otherwise, eviction is carried out. Sign and stamp, circle officer, Guwahati Revenue Circle. 248. 249. Now, we made Bonafide claim before the my lord authority through Kobula, my lord. The lordship will get that Kobula.
One second. We are at page 248 now.
248. Yes, miss. 248, that's speaking order, my lord.
Yes,
I am coming, my lord. Your lordship has already asked whether we file, my lord, made bona fide claim to the authority under Rule 18 of Assam Land and Revenue Regulation. Lordship, kindly come to the page 113. That is the Kobula we have made before the authority, my lord. Petitioner number 1, Monmil Boro, citizen of India, so and so, so and so, possess other within the, after the government land within the Para 2, my lord. I have been occupation 1 Katha, 5 lesser government.
you need not read it.
Yes, my lord. Then we have annexed the supported document. My lord, we paid the land revenue regularly, my lord. And we have given all these documents, municipality tax and other documents. Now I want to show something, my lord. Baro. আৰু আছে বেলেগ বেলেগ জেগা আৰু আগতেও দিয়া আছে কেইবিলাক সেইবিলাকত
Yes,
yes, ma'am. Then, my lord, after the passing of the judgment of the, my lord, this court in Honorable Justice Borua, my lord, we file a representation. Your lordship will get this representation, my lord. On চাব লাগে নে ইয়াতে?
yes,
Yes, my lord. 101 is the representation, my lord. 1911-2024 before the Deputy Commissioner, my lord. 101. we submit representation before the deputy commissioner, my lord, ventilating all the grievance we have and what our bona fide right before the authority, my lord. I am not read, my lord, if it is long, my lord, petition, my lord. I want to see two, three things, my lord. Para 7, my lord. Para 7, I will skip, my lord, because my lord, para 11 and 12. That the applicant back to state the government of Assam in the Department of Revenue had accorded approval on the same DAG 97 for settlement of land to one Madan Biswas, another Bankim Biswas.
You say that they have not received any eviction notice.
Yes, my lord. First, they are not receiving any eviction notice. Second thing is that, my lord, their settlement has been made on the basis of report and which has been accepted by circle officer.
That we have seen.
SDLC also say.
That we have seen.
Another important thing is that my case was filed, additional affidavit filed. They have filed affidavit in opposition. Same person has filed. They are silent about the settlement of Bankim Chandra Biswas, my lord. Then, my lord, I filed reply. They are silent. I argued the matter. You all say kindly look to the date. Consolidated affidavit said only one word has been said. Erroneously settlement has been given. I have produced all the report and that. Nothing has been produced. How the report is, my lord, wrong?
Where is that statement that erroneously it was settled?
Yes, my lord. Consolidated affidavit 470 given sila.
Page
473. एक मिनट 423 man. Yes, my lord. That man 478 directly come to the 478. And this affidavit was filed on when it was filed on, my lord. The Bolpuzar get a file with her. Your lordship kindly come page 478, my lord. 478 to the privilege of 478, my lord. May I read, my lord? The deponent back to state the settlement measure 1.39R, original cover DAG number 97 of Village Ulubari, Mouza Ulubari, Guwahati Revenue approval SDLC meeting held on 11/2025 resolution number 20. Accordingly, the said proposals are forwarded to the Revenue DM, Government of Assam from the District Commissioner Kamrup Metro of Height, letter number so and so 15 and wherein is erroneously noted that settlement proposals as proved by the SD in compliance of the Guwahati High Court order dated so and so, there is accorded approval of the settlement proposal, submission of copy, recommendation by GMD. Accordingly, the applicant deposited settlement premium, due process of circular Guwahati Revenue Circle.
No, right. We've seen that.
Is requested. I want to show one thing, my lord. This affidavit was 12 August 2028. This affidavit has been shown. And in my case, my lord, affidavit has been filed with the same person. Reply na affidavit of opposition 450.
358.
358.
Plus you also say that 315. Even if it is one thing, right? It's beyond it. Originally.
Lordship come to the 358. Nowhere they have stated in respect of my paragraph, in respect of Bankim Chandra Biswas, Madan Mohan Biswas, nothing has been said. And it was filed on 18 June 2025.
In summary, in your affidavit where you have raised this plea,
Yes.
there is no response.
Yes.
And subsequently, in a consolidated affidavit, they have just said, while admitting the settlement was done,
Yes.
but it says that it was in
Yeah.
terms of, though it was in terms of to judgment of the High Court, but there was no direction, so it was erroneous.
I am, your lordship is correct.
Ah,
Actually,
that
that's
is
correct.
person.
But
I
my
am
humble
correct or
submission
wrong?
before your lord, your lordship is correct. But my humble submission before your lordship that When the settlement has been made, Bankim Biswas, Madan Biswas, Arun Singh, that has been considered not that they take the signature. On the basis of report of the circle
Your
officer.
report is
Deputy
that
commissioner.
97 is not
Yes,
within the TB hospital.
Yes, madam.
Subsequently, when the deputy commissioner converted the land for from the TB hospital to the Pragjyoti School Hospital, then also drug number 97 was not here.
Yes, my lord. That
Drug
is the
number
thing.
97 was nowhere.
Yes,
When
my lord.
you raise this
Yes,
issue,
madam.
they have said it is erroneous.
And
No further explanation.
yes, my lord.
That's all.
Yes, but it is not a contingency lesson, my lord. That DB hospital land and Dagnama 97 is not contingency
It is
lesson.
outside the TB hospital.
Outside the TB hospital, there is a road, my lord. That side road, this land has been there, my lord. My lord, I am not opposing any hospital, my lord. If it is the land, it belong to the TB hospital. But
Yes.
yes, sir. But my lord, as per their documents, said this land is
No, we
not
have
being.
flipped your argument.
Yes, ma'am.
Yes, next.
Then another point of argument is that your lord says asked Mr. Deuri that we submitted the Kobula before the deputy commissioner. Deputy commissioner has to take the decision, my lord. Deputy commissioner has, my lord, delegate this to
circle officer,
to the
which you could not.
to the co-district commissioner.
District.
Co-district commissioner heard the matter. If that is the power by general or special notification, as I read, they can do all these things. In the affidavit, they are silent.
So your case is, though order is said to be passed by the deputy commissioner,
Yes, my lord.
the entire exercise was carried by an authority to whom power was not delegated.
Yes, my lord.
This is.
Yes, my lord. And subsequently, what happened after the my lord made an inquiry, speaking order was passed by the deputy commissioner. If your lordship go through my representation or other statement, my lord, although I denied this statement, blank signature has been taken. No fair hearing took place, my lord. OD ultim partem was not followed. But assuming but not assuming that is correct. What is the report in the speaking order, my lord? I am reading, my lord. There.
Your case is that whatever Bonafide claim
Yes,
I
my
have raised, that has not been dealt in the speaking order.
Speaking order.
Is it-
Yes, my lord. That is.
So,
Yes, sir. 241, no?
all right.
Yes, my lord. That is.
So we have read that.
Yes, ma'am. And 241, and another argument I tried to develop, my lord, before the single judge.
You have still not been evicted because of this stay.
Yes, my lord. I was not being evicted.
You have a house there.
I have a house, my lord. And
For the
also
last-
in
the
my
last-
petition, I said I am a landless people, my lord. I can show your lordship.
No, that you have shown, no?
Yes, ma'am. Landless people, my lord. And
Your, I mean, ace point we have noted.
that is my submission. And one, my lord, submission, my lord. They said their land is belong to the TB hospital, my lord. I give them, my lord, khazna. Also, Fauzi khazna. Meaning thereby they knows I am on that land, my lord. Just like a permissive officer. If that is so, if I am a land of TB hospital, then Assam Public Premises Act will be followed. I tried to satisfy you.
Tozi is,
It is a fine.
fine.
Yes, ma'am.
Law is well settled.
Ah.
And at the same time, it is also well settled that Tozi, those who pays Tozi,
No.
can that 18 can be applied.
Yes, well, yes.
Is that it? So why you bring in that?
Yes, my lord.
law?
That is why.
All right.
And one point, my lord, A.K. Roy, your lord, King Nazir, my lord, MPR, 10. Power has been given to do certain way. That should
Oh.
be that way.
Right.
Yes,
It
sir.
is, you
Yes, ma'am.
you don't deny that this power could be delegated, but there had to be a special delegation or a general delegation.
Affidavit is silent.
All right, we have followed that.
Affidavit is
So
silent.
therefore, the sum and substance of the argument would be that since the power has been exercised by an authority which is not vested with the power,
Yes, my lord.
then it is a order in nullity.
Yes, my lord.
Uh,
And
great.
delegation notification was not annexed in the affidavit, my lord.
It was therefore good. You have qualified your statement. Whether there was any delegation or not, that is not stated in the affidavit.
Affidavit.
But you do not know,
Yes,
right?
ma'am.
You have not
Whether-
made any statement beyond your knowledge.
Yes, ma'am. Whether in one cases, my lord, they have admitted that Suresh Chauhan, my lord.
All right.
Fairly admitted by them.
Yes, Mr. Chaudhary. So you close your argument at this.
Yes, ma'am.
Sir, your items, Mr. Sudhir.
Item 8.
Only the first item.
Yes, ma'am. Other, I adopt, if you also think that I am not entitled, I adopt the argument made by Tapar Deuri. Unnecessary, I will not. Yes, sir.
All right,
Yes, sir, not.
all right, that's in the alternative.
Yes, madam. But this is my primary argument, madam.
Now we have heard eight, then who appears in nine? Acha, with nine, eight with nine is the same person. But nine, somebody else is appearing.
Nine, somebody else.
Who appears in item number nine?
My lord, I'll just take 5 minutes of your.
No, who appears in item number nine?
My lord, we are appearing.
You are appearing. For rest of the appellants, you are appearing.
Only for the 9 only.
Only for nine.
Item 9.
And others, though he has done, no? All right, item number nine, yes.
No, my lord, very short argument, please. My lord, it's a human problem to be sorted out with human touch. And it is undeniable, my lord, the DC is the all authority to settle the land. Keeping back in mind, my lord, my only submission would be, my lord, I'll take your lordship with all endeavor with the learned advocate general. If they are rehabilitated in a relocation place, the matter can be sorted out and it is within the very well jurisdiction of your lordships. Well, to that effect, my lord, I will take your lordships with judgment of Delhi High Court.
Sudama.
Akin with the Sudama, my lord, is by Ajay Makan, my lord, the party's name. I'm just handing over to copy of your lordship. Is 196. I'll take your lordships to paragraph 196. Please. This is the observation given by the lordships.
Page, paragraph?
Paragraph 196. The lordship got it. Once a JJ Basti cluster is eligible for rehabilitation, the agency should cease viewing the JJ dwellers therein as illegal encroachers. The decision of the Supreme Court of India on the right to shelter, the decision of this court in Sudama Singh require a court approached by persons complaining against forced eviction, not to view them as encroachers and illegal occupants of land, whether public or private, but to require the agencies to first determine if the dwellers are eligible for regulation in terms of the extent, law, and policy. Forced eviction of Johagi dwellers unannounced in coordination with the other agency and without compliance with the above steps would be contrary to the law explained in the above decisions. So this is the very short area, my lord, where your lordships may, my lord, give some relief to the petitioners here. And my lord, your lordship may see also another decision of the apex court.
Read paragraph 197 also. That will be another adjunct of your argument, which we will take into account.
Right. In view of the positive stand of the respondents, including the railways, and in terms of the DUSIB Act, the 2015 policy and the decision of Sudama Singh, it is essential to first complete a survey and consult the JJ dwellers. There is, as of now, no imminent possibility of eviction of the JJ dwellers of the Shakur Basti. If no in situ rehabilitation is feasible, then as and when the respondents are in a position to rehabilitate the eligible dwellers of the JJ Basti and Juagis in Shakur Basti elsewhere, adequate time will be given to such dwellers to make arrangements to move to the relocation site. The right of the JJ dwellers to raise objection to so-and-so and the protocol to seek legal redress at the appropriate stage if the occasions are.
All right.
So, my lord, and your lordship is well aware that due process of law. The due process of law means, supposing, my lord, assuming that I'm an encroacher, even in that case.
So you just read that, no? If a person is eligible for rehabilitation, question is this, that see, many of you, including Mr. Chaudhary's clients, they were having a patta. They were staying on the land, they were paying rent, wrongly, rightly, they were there. So therefore, they would fall in the category of people who need to be rehabilitated.
Yes.
This was no largest to them.
It was only a step towards rehabilitation, and
Yes.
therefore they were placed there. So in that case, they ought not to be looked at as if they are encroachers.
Right.
That is what the bundle of rights as enunciated by various Supreme Court judgments.
Exactly. Your Lordship has seen all is on all that. Well, ultimately, the thing of the case is that the rehabilitation is ultimately
That
the
argument
answer.
is well taken.
Yes.
We'll be confronting the Advocate General with this. What we
Right.
decide is something different, but what we will confront him with
The
this.
Advocate General may help us in view of that
Let's
position in order to rehabilitate us.
Let's see. Advocate General means the state may help you.
Throw him, my lord. I'm saying throw him.
All right. Anything else, Mr. Datta?
That's all, mate.
For rest of the appellants,
Lordship, I'm supporting this submission.
you adopt the arguments. Just give your appearance slips and certifying that you have appeared in these matters.
Yes, Lord.
Now we'll hear the Advocate General now.
The learned AG is start up in some emergency matter, my lord. It's code number 4.
All right. So you'll,
He has instructed me, my lord,
all right.
to address all the queries that may be posed by your lordship. I have been duly instructed.
All right. Now tell us three things.
My lord.
The argument of Mr. Chaudhary you heard. Now merely saying that it was erroneously settled,
Right.
is it going to help you?
My lord, because those settlements were done, my lord, those were 3 or 4 settlements were done, my lord. Those were done albeit erroneously, my lord. Before through the direction passed by the Reed Court, my lord, in the earlier round of litigation. Now, what was the genesis for the settlement? That lordship will kindly see, my lord. The judgment, my lord.
And then the supplementary question would be,
My lord.
then why have you not issued eviction notices to Biswas brothers?
Because, my lord, the land have already been settled and they have attained the status of a patta holder. Now, having attained the status of a patta holder, we cannot, my lord, resort to summary eviction proceedings. We will have to acquire that land. Either acquire that land and, my lord, the honorable single judge, my lord, which in the judgment which is put to challenge hearing, has also given a leeway to the government, my lord, to take appropriate measures even for cancellation of the patta. So that road is always open for us, my lord. There are only 3 or 4 persons, my lord, who have been given settlement before the rule and in completely, my lord, distorted interpretation of the decision of the learned Reed Court. That lordship will kindly find, my lord. If lordship may be pleased to take item number 8, my lord. That is the first item, 1 mil borrow. Page number 494.
What does it say?
Yes, I'm reading it, my lord. Paragraph number 14. The individual that Reed application. That Reed application was moved by Arun Kumar Singh, who was, my lord, by passage of time was given full and final settlement. And the relevant paragraph as 494 is, my lord, the individual application be made by the petitioner within a period of 1 month from today, and upon such applications being made, the Deputy Commissioner Kamrup Metro shall give a due consideration and pass reasoned orders after giving all opportunity to the petitioners for a hearing and also to produce any relevant material, document, testimonials, etc., that they may rely upon, and thereafter pass a reasoned order on the claim of bona fide right made by the petitioners. Depending on the order to be passed, consequential action to be taken. In the event no right is found, the petitioners be evicted, and if any right is found, they be allotted a suitable land as per the land policy, but that does not mean that they continue their encroachment over the government land. This paragraph was totally misinterpreted by the authorities down below, my lord, at the district level, and they gave a meaning to this, my lord, dictum as if they were directed to give settlement to those persons. Accordingly, my lord, those settlements were given. And only 4 persons.
there are almost more than 100 households are there who are illegally occupying the part and parcels of land which has been reserved for TB hospital, and that practice.
One second. Has the hospital come up there?
Yes, it is almost already a hospital is in existence. That is my TB hospital. Now it has been renovated and it is going to be the second medical college come hospital at Guwahati to be named as Pragyotispur Medical College. And that will be a super specialty hospital. The building is almost complete, my lord. It will be inaugurated soon, my lord. The new structure.
So therefore, these persons who are paying Toji and were residing neighborhood, without their eviction, this hospital building came up.
This hospital building came up, but the annexes are there, my lord. This cannot be constructed, my lord, without their eviction. That is the difficulty. Because their whole land is here, my lord. Lordship will kindly appreciate, my lord. It is not that, my lord, within a particular period of time, my lord, the building is set up, my lord, and it will end everything here. It is the need, my lord, progressive needs of the patients, progressive needs of the society, my lord. It goes on in that manner.
All right, then what do you have to say about this? Now, all said and done, they have acquired the right for rehabilitation because of their being allowed to stay on the government land for last 30 years.
Yes, I will answer.
No. Yes. That is answered by the Supreme Court decision.
The Supreme Court.
So they have a right. So what do you have to say about post-eviction resettlement, relocation?
Absolutely.
Because they are no encroachers now.
Yes.
They don't fall in the category of encroachers.
Right.
Am I making sense to you?
Right.
For the reason that you allowed them to stay on that land for last 3 decades, then they are no longer encroachers. If they are not encroachers, then they need to be rehabilitated.
My lord.
Where, if in situ rehabilitation is not possible, what Mr. Datta read? If in situ rehabilitation is not possible, then somewhere else.
Absolutely.
And then till such time, reprieve. That's what the judgment says. Not that we are suggesting it, but that is what the judgment says.
My lord, if I may put it in this way, my lord, the state of Assam, my lord, we have, my lord, special schemes, rehabilitation schemes for persons who were affected by erosion, who were affected by riots, my lord, who are affected.
Also, we are aware of that.
My lord,
Mr. Sharma, that doesn't help.
I'm coming, my lord. I'm coming. I will explicitly, my lord, answer to my lord's query, my lord. Now, those schemes are there on place. Here is a case, my lord, where these persons, having fully known well that this part and parcel of land is reserved for TP hospital, none, or to put it otherwise, this is a government land, with their eyes wide open, came into occupation of those land. And they started.
The argument is not correct.
Well,
for the reason that you are expecting these landless people who are settlees there, not settlees, what is the expression? Occupiers. So you want them to have their eyes and ears open. And not yours, where your district deputy commissioner says that it is not hospital.
Absolutely. Now, my lord, the thing is that, my lord, under the land policy, now the land policy in Assam is a pan Assam, my lord, it's a pan Assam state. What has happened for all these years is that, my lord, they have been constantly, my lord, filing one application after another, my lord, before the authority, seeking settlement of that land, my lord, over which they are in occupation. If they file any other application before any other place, my lord, definitely that will be considered. Because in Assam, my lord, there are so many part and parcels of government lands are there. But not here in Guwahati.
What do you suggest for them now?
They may file an application, my lord. They may file appropriate application. They may identify land. Or they may prefer applications, my lord. Before the district commissioner Kamrup Metro, that look, kindly, we are now to be evicted, so kindly allot us land, suitable land.
You give this proposal.
My lord.
Land is available in this area.
So that is true, but my lord, they will have to.
No, they will.
They will.
Why? Simultaneously with eviction notice, you tell them that, well, from here you'll have to go.
Yes.
But then we are not leaving you on the road. this is the land which we have allocated for settlement.
It will be-
Apply there.
Absolutely, it will be somewhere outskirts of.
Wherever, wherever.
It will be, my lord.
Nobody can have a right to stay.
Absolutely. That is-
Nobody can have a right to stay near
Yes,
Digul
yes,
Pokri or
yes,
someplace.
yes, yes. That is the, my lord, LOC, if I may say so.
So you give
Yes.
that.
My lord, definitely, the state is already there. My lord. But they will have to move an application before the authorities. My
So
lord.
you have to tell them where the land is available.
My lord,
Suppose you tell them that please go to somewhere in Tej. farthest one. No, no, sir,
my lord,
Suppose you give them the offer that, well, some land is available in Tejpur or Vishwanath,
Yes.
Chereli.
Yes.
That is no offer.
No, my lord, Lordship
It
will
has to be somewhere.
Lordship will kindly appreciate, Lordship, I will take only some time. Lordship will kindly perceive one situation, my lord, here is a government plot of land. My lord, I come into occupation, even for 1 day or 2 days, I sit here, my lord. And if, my lord, I stop to be evicted, then everybody will start, my lord, enforcing government land, then seek for, my lord, settlement.
Mr.
My lord.
Mr. Gaur Pujari, you're right. It is a humongous task for any state to accommodate all of them. With the teeming millions not having any place to stay, but the difficulty is that we are a welfare state. They are indigenous people, they are not infiltrators. Correct? And then they were staying on the government land this way or that way, not stealthily, but by paying toji. Correct? So they may not have any right to stay there, agreed. But we don't call them encroachers. So therefore, it is a difficult task for you, no doubt, but you are a big organization, a state meant for people. These persons have voting rights as well. We can understand how far these, under the garb of, being a welfare state, how many would be accommodated. And there is a guarantee under Article 300, you can't acquire lands of private persons unnecessarily for accommodating these persons, these landless. All this sealing laws and other things, those are only for those purposes.
Absolutely. So therefore, my lord,
and it is not only providing land. Right to shelter is a bundle where you'll have to provide right to medical aid, right to education, right to livelihood. It is only under those bundle of rights that, the pavement dwellers, what is that called? The weekly bazaars, what is it called? Hearts are organized. Now it is a difficult task. If you start thinking about it from the mindset of a private individual, you'll find it very difficult. I can tell you how difficult it is for a private person, but you and private person, and they are two different kinds. My ancestral home was, there was a huge tract of land behind my house in my village. Now, sometimes in the past, when my great-grandfather was there, he asked few people to settle. They made their huts. Thereafter, their children, their grandchildren, their great-grandchildren. Now there are 300 people residing in the plot which is owned by us. So we have really abandoned that. Nothing can be done to recover it.
Absolutely. Because the problem assumes manifold significance, and more particularly, it is more subjective rather than objective. That is the difficulty. It is so subjective, my lord. So therefore, I am.
No, we are not asking you to give them any land. We are only asking you whether you have a relocation strategy.
It is already
in terms of the policy.
Yes, it is already there.
Yeah. Post eviction. What is there? That is a general policy.
Yeah, that is a
post eviction. Post eviction, not of squatters,
yes,
not of encroachers,
yes,
but of persons of this kind.
yes.
This is a separate class.
Absolutely. Absolutely. To that extent,
As I understand it, they're a separate class.
yes, yes. To that extent, my lord,
They are not there for last 6 months or 1 year.
Yes.
So kahin to, somewhere you locate them.
You recognize, Mr. Proposer, that we need to, even if they are there, we, after eviction, we should reset it. Where is that policy? How, when, where?
that is
Don't just get back to
my lord, in the land policy. Lordship is absolutely correct.
No, if you remind us of that policy, that doesn't satisfy us. Where is this policy now in terms of the judgments, in terms of the
Yes,
act?
whatever lordship
See,
has
none of
spoken,
them, even if they claim that they be given in situ reclamation, what is it called? Rehabilitation,
Yes.
that claim would be non-existent. Nobody is going to give that. No, they are not claiming it now. They're not claiming it now. To adopt the line of least resistance by the state, they are not claiming it. Now, tell them that this is the place which we have allocated.
Absolutely, my lord. We are
Absolutely, you say, but when would you identify?
My lord, we have to
See,
take
on
a
principle-
magnanimous view of the matter. That is understood, my lord. But I am apprehensive only on the fact, my lord, that it may not be possible. It is near to possible, my lord.
It's difficult.
Difficult.
I would not say impossible, but humongous, very difficult.
Yes, to provide the land within the district of Kamrup Metro. Within the district of Kamrup Metro. Let us
We
point out
understand.
that, my lord.
We understand that.
And the rest, my lord, they may file.
But obviously, not Tejpur or somewhere near Arunachal.
Balanced lordship is always there, my lord. The authorities are there. But what I would, my lord, pray before this honorable court, let them file their applications, my lord, to the revenue department, because that is the department government for the state of Assam. And let them file their applications, my
Till such time, what do you suggest?
till such time, my lord.
I mean, where under the sun would they
Yes,
live?
yes.
Very difficult. I mean, every time we are saying it is very difficult.
Yes.
They don't have a right as such,
Yes.
but we have a duty.
Yes.
Without their corresponding right,
Yes.
we have a duty.
Yes.
At least to let them survive.
Yes, absolutely. Because they will have to move out from their places, of
Where
occupation.
would they go?
Yes.
Not on the railway station, not on the
Absolutely,
platforms.
absolutely.
There are not few, there are many.
Lordship will kindly give us some reasonable time till then they will be there, my lord. Let it be, my lord, 3 weeks, my lord. Let us then take a call within 3 weeks. Let the lands be identified and be spelled out to them, my lord. And they will have to move forward. Not beyond that.
Mr. Borpujari, this statement should come from the Advocate General. We will record it.
Absolutely, absolutely. Then may I then, my lord, let this matter come up on Monday.
No more. No. We will close it today. You can file any application. We'll close it today. Because see, one matter cannot be heard for so long.
Absolutely. I take it.
So we'll close it today.
Well,
We will deliver the judgment later,
Right.
only after you tell us.
absolutely.
Or if you don't tell us, then we'll have to devise some ways, no?
But definitely it will be intimated to this honorable court. My lord, let me take specific instructions from
No,
the AG.
they have abandoned their stand of rigidly pursuing their right at that place. None of them have. I think none of the advocates who have addressed us. No, not even Mr. Chaudhary. Mr. Chaudhary also has abandoned that kind of a right.
Because it is the first basic element in the my lord, field of economics, land, labor, capital organization. Land always, my lord, goes first. So therefore, land is something, my lord, everybody will fight for. My lord,
And winters are approaching.
yes, but I have not received a instruction from the learned AG, my lord. He has requested, my lord, to post this matter on Monday, my lord, only to that extent. Scheme of rehabilitation.
All right.
Otherwise, lordship has already heard it, my lord. I need not. But
But we want to hear it from the mouth of. You are also equally
No, my-
competent,
my-
but for recording that we have
yes,
heard,
yes, yes.
this is
Yes.
we have heard from Advocate General. We need him.
Only to that extent, my lord, relocation.
Would he be free by around 4?
My lord, today it is, my lord.
Not possible.
My lord,
So all right,
all
Monday.
sincerity, my
No, Monday. Monday we will have all the matters listed.
Mr. Deori, some of your writ petitioners have already been evicted.
No, your lordship.
No, not
No,
evicted.
that's a separate bit of writ petition, your lordship. It's pending.
Already been evicted.
Some are effective.
That's why I'm.
Who is representing them?
But
No, it's
they
a-
had filed writ petition before this honorable court, my lord, after they were evicted. So they have now, my lord, gone to some other places.
No,
No,
I am declaring.
no, head to the. It will be there, it will be there.
No, my lord. In one of my case, man, Pulmoni Talukdar, I have given. There is a order has been, they should not be evicted, my lord. First, you heard the matter and in the,
Anybody evicted?
No, your lord.
as far as,
Some writ petition.
no,
See,
my client was not
with
evicted.
permission of.
Yes, sir, my client was,
Justice, there are two sets from the same place. One is already evicted.
Already evicted, those writ petitions have been disposed of, my
Disposed.
lord, disposed of to the extent, my lord. Even if, because we have stated in our affidavit.
They filed for rehabilitation and all.
Yes,
And where is it, those writ petitions have been disposed of, saying what?
saying, my lord, if they are already been evicted, because they have denied eviction in our affidavit, so there is a disputed fact. Now the honorable court says if they have not been evicted, then, my lord, they may be given a right of clearance.
And suppose if they have been evicted, they say that they have been evicted, they are on road.
They have been evicted. then-
Those writ petitions, are any one of those writ petitions pending? Do you have an idea?
No, my lord.
No.
All writ petitions have been disposed of.
Can you check up? Because we are postponing it for Monday.
Yes. My lord, yes.
Can you check it up? In that case, we will have those writ petitions also clubbed here.
Yes, my lord.
So that single judges also do not start passing orders differently.
Absolutely. I will. But so far as I remember, my lord, all the writ petitions have been disposed of by the honorable single judge.
yes, sir. But different order passed. In respect of my Pulmoni Talukdar case, I have given order. Here, my lord, I was there, my lord.
Mr. Deori, most of the cases of you all evicted.
Three of the cases I was evicted. So
Order.
those cases are different cases. This is not part of this.
Agreed.
Yes, sir.
Orders. Can you provide us the
Yes,
orders?
definitely I can.
These are disposed of
Yes, sir, disposed of your lordship.
with a direction.
With a direction to approach the authorities for again filing an application for consideration of our
So
cases.
consider, because the dispute has been raised on board, my lord. We say they were evicted, they say no, we are still interested. So therefore, honorable single judge has said.
But that's right. But
No.
we have yet not
Yes, sir.
concretized our opinion what we are going to do.
That is
Correct.
the order in my case.
Just a minute. Now, suppose we find that it is possible for all of you to be rehabilitated at some other place. Don't insist for any specific location.
Yes, I agree.
My lord, as per my,
The moment you do that, then it no longer becomes a claim for seeking shelter. Then it becomes, as if you're trying to enforce a right.
but my lord, sometimes what happens, here, my lord, they will say that we are relocated the people. After disposing the case, my lord, nothing has been done, my lord. Because in this order also single just said, nothing has been done.
No, that bit.
That is an order passed by this honorable court. What had happened thereafter, my lord, it is for the person concerned, my lord, to spell it out. My lord, what had happened thereafter, it is for the person concerned, my lord, to spell it out.
It's not going to end. And Mr. Botpazari, you have to undertake that task also, which all persons are, you have to take a composite view and you have to identify all such settlers so that you frame a policy.
Absolutely.
You can't do anything without having a policy, without having it, the clearance of the government. These things can't be decided in courtrooms.
Absolutely. I will have a, my lord, due deliberation with the learned AG, my lord, on Monday, definitely, my lord.
We are not asking you for much.
Right.
We are not asking you for a choice. We are only concerned that these people should not die of the vagaries of nature
Lordship is
without
absolutely-
house.
My lord is absolutely correct in saying, my lord, that this class of people form a definite class in themselves. This is not, my lord, imbibed or.
The encroachers, we are absolutely not inclined to pass any order. Encroachers, squatters, nothing. They also deserve sympathy, but that would be a misplaced sympathy.
Lordship has recently
They are-
dealt with my lord forest and encroachers.
They are different.
They stand on a different footing. Here is a case, my lord, where yes, specific, my lord, rules and regulations are not
Under
there.
policy, you recognize their right also.
Yes.
This kind of.
Yes.
Yes,
yes,
sir. That
yes.
will give settlement even government land.
Even today, my lord, they can very well move to some other district. The difficulty again,
Where
my lord,
is
I'm
the
repeating.
My lord,
My lord, land side-
my humble submission before your lordship is that, what is the history of that land, my lord? Whole Rupnagar and Birubari, my lord. If they say these things, my lord, tomorrow, my lord, there are at least, my lord, 5 lakhs people settled there, my lord, in government land. Some has got the patta, some not. Basically, it is the land of Mahendra Mohan Lahiri, my lord. Huge land has been ceiling surplus land. He has not, that ceiling surplus land has been
What about GS Road? Not RG Burwa Road,
in Nalbari, my lord.
the left side, still all are.
But can I ask one question from all of you?
Sure.
You must be charging fee from them for arguing this case.
Yes, sir, of course. But they are, my lord, person of weaker section of this society, my lord. Minimum fees has been taken.
All right. Take them. We have heard Sri Datta London.
Just a minute, my lord. On Monday, my lord, my presence will not be there. I'll be out of station. My lord, any sort of eviction may be subject to fulfillment of the rehabilitation. Your lordship kindly see that.
We are contemplating that. We are
Obvious.
contemplating it, but
Well.
let us see the feasibility.
Right.
They are contemplating it. Let's be frank. I mean, otherwise we would not have entertained such.
Yes, yes.
Not.
Well, your lordship, excuse me, I will not be there.
All right.
Obliged.
We have heard all these batch of appeals have been taken up together for consideration. We have heard Sri Datta Leonard Senior Advocate Pattanamli announcements in separate sets of appeals. Most of the appellants were residing on government land after paying Toji for the last 3 decades. It was much late in the day that the government took the stand that the land on which the appellants were residing was earmarked for construction of a hospital and later for another medical college, which fact has to a large extent been attempted to be disputed by the appellants. The appellants have further argued that they ought not to be treated as encroachers or squatters for the reason of their long stay on the government land, not stealthily, but under the recognition of the agency of the government. In any view of the matter, if the claim of the state is correct, that the land over which most of the appellants have been residing is required for completing the construction of a medical college, then the appellants do require to be rehabilitated post their eviction. They require to be rehabilitated post their eviction. The learned advocates representing the party, representing the appellants, have drawn copious references from various judgments of the Supreme Court, which have acknowledged the obligation of a welfare state to provide shelter to landless plus homeless. In fact, a few of the judgments also recognize that right to shelter is not to be understood in silos. First of the right to shelter is a bundle of rights which includes within its ambit the right to medical aid, right to livelihood, right to education, and right to carry on trade/vocation for earning the livelihood and sustaining their lives, sustaining the lives of the citizens. Though settlement policy of the government is in place, but we would like to know from the learned Advocate General whether there is any policy in contemplation for rehabilitation of such class of persons who had hitherto been residing on the government land post their eviction. Mr. Borpuzari, learned advocate for the state, submits that the learned Advocate General shall respond. On Monday, on Monday, bracket 28th. Let all these appeals be listed under the heading orders. Admission. Under the heading order, under the heading orders on so and so date.
Much obliged.
Chalo, next. NNB21.
Item 27.
Maybe.
Yes.
My lord, in this case, the appellant is challenging order dated 19/9/25, my lord, by which the writ petition filed by him was dismissed, my lord. On the ground, my lord, that the petition was seeking, my lord, relaxation in the appointment advertisement, my lord. It was actually, my lord, that was not the case of the appellant, my lord. The only dispute is, my lord, that the appellant has not uploaded one document, my lord. My lord, the case of the appellant is that he has uploaded the document and the respondent also admitted, my lord. The problem is that this document is the, my lord, certificate, and on the back side is the endorsement, my lord. They are saying that the back side portion is not there. Appellant is saying he has uploaded both the portion, my lord, first this part and back side part. That is the only dispute, my lord.
Now, have you annexed that copy?
Yes, ma'am.
Where is it?
My lord,
Show us the page.
My lord, page 35. Page 35 is the, my lord, the certificate, and page 36 is the, my lord, endorsement.
ये लगाया है इसकी नहीं इसको सर्टिफाइड करना है दूसरे ट्रस्ट नहीं एक This is by chairman of the boiler attendant examination board from chief engineer. ये correcting नहीं इससे नहीं ये बता ये correcting नहीं ये correcting is not hard one. He has taken notice before. Out the other. Boiler authority, chief inspector of boilers. Is it the same authority? Which would be class 2. BBC क्या हुआ? Which है BBC?
BBC second. What is BBC second? Boiler competency certificate.
BBC.
Now, show us from the eligibility requirement, how to apply. It has, everything has been quoted here in the judgment.
Yes, yes.
Now, let us see what is the requirement, whose certificate was
My
necessary.
lord, the requirement is, my lord, that either, my lord, this, this.
Where is
From the judgment
yes,
you show.
Yes, yes.
41.
Page 41.
Below,
Which paragraph?
my lord, last paragraph, junior engineering assistant, uh, code number 202, my lord. Refinery,
Boiler competency
Boiler
certificate
competency
with
certificate,
second
this is-
class or national apprenticeship certificate in boiler attendant under the Apprentice Act with due endorsement equivalence by the competent boiler authority of the state of the competent or लिखता है कि boiler competency certificate with second class or national apprenticeship. Is it the same authority?
My lord, this authority is not in this, they say, my lord, that this portion is not uploaded by me. my lord.
No. That the single judge has taken note of, says, no.
Yes.
It's not a question of oversight.
My lord.
The endorsement is not by the authority which has been notified in the advertisement. That's what this.
No, it is the same authority, my lord.
It is the same
My
authority.
lord.
My case is different. My case is that.
Who are you?
Upload, I'm the Indian corporation.
So your case is, it is not your case, it is your stand.
My stand.
I thought you were appearing for some other
My
similarly placed appellant or petitioner.
My stand is that the particular certificate which was required to upload, madam, he has not enclosed that. He has enclosed the certificate of completing the apprenticeship training in the refinery.
And what else was required?
This was required, madam. What he has.
This endorsement, this endorsement is not.
Endorsement.
That,
Lord,
my
will
lord,
kindly come to page 35. madam.
You are being hyper specific.
35 is issued by the, my lord, Directorate of General of Training.
You have asked
Page
us,
35.
page 35 is,
Of the requirement.
this is the certificate.
This is the certificate that he has completed the apprenticeship training in the refinery.
All right.
Now, the requirement of the advertisement is that this certificate has to be endorsed by the boiler authority, which is at page 36. This is separate, man. This is under the boiler rules, man. Merely having this certificate is not enough. This certificate has to be endorsed. Then he becomes eligible.
No. So this endorsement, you say it is not the correct
No,
endorsement.
it is the correct endorsement. This was not uploaded, man.
That is on the second page
No,
of the certificate.
what was uploaded, it is, in fact, I am told that that particular page is not there in the petition. What was uploaded is a certificate of the, issued by the refinery. That is not enough. This I am told, my lord, is not part of the writ appeal.
No, 35, they have given it, but there is no endorsement. It is not even as that. Now, can you produce the original application?
My lord, it is an online application. I'll definitely.
Online, I mean, online can always, you can always download.
We'll download it. To it, you know.
Because he says that it is, we understood it as a certificate or an endorsement by another authority. No, you say that it was not endorsed at all.
No, madam, it was not uploaded, madam. What was uploaded was this.
Only this was up.
Only this was up. This is a certificate. I am told, madam.
Where have you said that in your reply before the writ court?
Yes, madam.
Have you?
That is in fact quoted in the judgment, madam.
No. This was, this certificate was uploaded. This was uploaded.
No, madam.
He uploaded something else.
No, my lord, they say that front portion I uploaded and the backside portion I have not uploaded. That is their case.
That is what we understand.
Kindly come to page 86, my stand in the affidavit. That is quoted in the judgment.
Page 86.
If you not take the
Yes.
judgment, it is at page 109.
No, you refer from page 86.
Page 86, my lord, fifth line from the bottom, my lord, the petitioner. Lordship has got it?
Yes.
The petitioner did not upload the national apprenticeship in boiler attendant with the required endorsement of the competent boiler authority of the state which is equivalent to the second class boiler attendance certificate of competency. Instead, the petitioner had uploaded the apprenticeship completion certificate issued by IOCL Guwahati Refinery, which does not have the required endorsement from the Boiler Authority of Assam, nor is the required certificate.
Totally. But that is not what the judgment says.
Judgment quotes that number. In fact, I am told by
Page-
the
page and
internal
judgment-
page 14 of the judgment is also not part of the writ appeal. Is it there? 110, Lordship, it
Yes.
comes to 110.
Page 110, my lord, para 22.
Para 22 of the judgment.
Para 20.
Para 22. It is not.
No, para 22 is something else.
22 man.
Para 22 of the judgment is something else, not what your affidavit says.
No, madam. Lordship will kindly read it, madam. Again.
Don't say no, just read that.
I will read it. In the case in hand, though the petitioner has stated that the boiler apprenticeship certificate has been uploaded, however, the requisite endorsement appearing in the backside of the said certificate perhaps was left out due to over.
This is what the court says.
No, madam. This is the submission, madam. The petitioner has stated.
No.
Though the petitioner has stated that the boiler is up, however, the requisite assurance is not. However, it is difficult to accept the said contention of the petition. Inasmuch as the respondent IOCL has categorically denied.
You produce the original form where he has said. He can't make a wrong statement like this on oath, no? Where is that copy, photocopy which you have?
Yes, I have.
Show it to us.
No, photocopy of the form.
No, that which you had uploaded. You
Yes,
must be having copy of the
yes.
photocopy of what you have uploaded.
I can produce original also, my lord, but photocopy please.
So had he uploaded this, you would not have shut him out.
Had he uploaded both the pages, ma'am?
But this he had uploaded.
No, he has not uploaded. That is my stand.
So why do you insist on both the pages? Then perhaps we tend to understand that only the back page you did not see.
No.
So this certificate in its entirety was not uploaded by.
That is my.
That's then it's an oath against an oath. You uploaded it.
Yes,
Where
I
is your
uploaded, my lord.
original receipt?
It is online, my lord, and they have not denied, my lord. They said that I have not.
They have denied it.
No, my lord, in their.
No. Both of you are in the habit of saying just no.
My lord, in their affidavit, they stated that this endorsement was not.
No.
Not uploaded.
They say that what you have not uploaded this at all. What you have uploaded is a certificate of completion by the refinery, not under the Boilers Act.
My lord, but this is.
So therefore, this has to be verified.
No.
If you had not applied this, if you had not uploaded this, then your
Yes, no,
application,
let them.
then your application goes.
Yes, sir, yes.
We can't help it.
My lord.
But otherwise, we are entering into this thicket of controversy only for the reason that you have obtained 66 marks out of 100, and otherwise you would have been taken in.
My lord.
You were only second in the merit list for OBC category.
My lord.
Correct?
My lord.
So therefore, we are having sympathetically, we are considering your case. But if that statement is not correct, then we will charge IOC for making a wrong statement.
My lord, one more thing, my lord. Actually, my lord, they were to this, my lord, they were to declare the, my lord, the mark within 2-3 days, my lord, and there was a.
That we can't take notice of that. It's a long drawn process.
My lord.
The recruitment process, gentlemen, we understand. We undertake a recruitment process. It takes time, day in and day out. So those delays we are not going to take into account.
My lord, my lord, suppose they say that I have not uploaded this, my lord, I could have, my lord, I could have shown them that yes, I have uploaded.
That's right. That way, that point you have,
My lord.
that if your application was deficient in any respect,
My lord.
normally the recruiting body gives time,
My lord.
or let it be known to the concerned candidate that you please fill up this has not been
Well,
uploaded.
this
But
this
you
was
don't-
also mal, part of
But
this
you don't
advertisement.
expect the employer to be so kind and so
No,
considerate.
my lord, it was the condition, it was the condition
All
of
these
this
expectations,
advertisement also.
I mean, somehow the other, which I don't understand, all these expectations are from the judiciary only. You don't expect it from the employer, you don't expect it from the government, and you want us to interfere.
My lord,
And then you are the one who would comment against the judiciary of its overreach. That is the problem. The whole of the application that you have received online, please produce it. Take down. The appellant has questioned the judgment dated 19/9/2025, passed by a learned single judge in WPC number 736 of 2025, whereby the decision of the respondent IOCL to non-suit the appellant has not been interfered with. The appellant had applied against an advertisement issued for recruitment of non-executive personnel, including the position of junior engineering assistant dash Roman 4 bracket P and U, for which 10 posts were available, and out of which 3 posts were reserved for OBC category, from which the OBC category, full stop. The appellant hails from the OBC category. Stop. The appellant claims to have undertaken the computer-based test on 29/9/2024, in which he came out successful. No, in which there is in the result of which the name of the appellant did not figure. It was only after a delay that he was informed that, within quotes, apprenticeship certificate submitted by him, not within quotes, he was informed that the apprenticeship certificate submitted by him did not have the endorsement from Boiler Authority of Assam as equivalent to BBC second class. The claim of the appellant is that the apprenticeship certificate with the necessary endorsement from Boiler Authority of Assam was uploaded, but the endorsement from the Boiler Authority of Assam, equivalent to BBC second class, was made on the backside of the certificate, which went unnoticed. This, it may be stated here, was one of the eligibility criteria for applying against such posts. Applying against such posts. The stand of the respondent IOCL is that in fact no such apprentice certificate was uploaded by the appellant. Semicolon, rather, an apprentice certificate issued by the refinery was only uploaded, which was not the required certificate under the criteria spelled out in the advertisement. Notwithstanding the aforenoted stand of the respondent IOCL, the communication made to the appellant reflects otherwise. Stop. The communication clearly states that the apprenticeship certificate submitted by the appellant did not have the endorsement from Boiler Authority of Assam. Based on the stand taken by the respondent IOCL that no apprenticeship certificate with the necessary endorsement of Boiler Authority of Assam was ever uploaded by the appellant, which the appellant denies vehemently, comma, the case of the appellant was dismissed by the writ court. Looking at the communication made by the recruiting body to the appellant, we get an impression that it was only because there was no endorsement from the Boiler Authority of Assam that the apprentice certificate was not accepted. And the explanation offered, coupled with the explanation, this impression is further strengthened with the explanation given by the appellant that the endorsement unfortunately was made on the backside of the certificate, which perhaps went unnoticed while his application was being verified for necessary particulars which were required to be uploaded. The appellant came to learn later that he had obtained 66 marks out of 100, and if he were considered, comma, he would have ranked second in the OBC category, for which 3 posts were earmarked. Under such circumstances, we direct, what is your name, Mr.?
N. Dekaman.
We direct Mr. N. Deka, learned advocate representing IOCL, to produce the entire uploaded application form of the appellant by the next day. Re-notify on so and so date. Your communication says otherwise.
I understand.
And therefore we have stated it. No. They would employ somebody else. If we find, we would fix a early date because it concerns employment. There's a feeling inside us which without confirmation we will not act upon it. That you have that there was an oversight, and this is a second round of explanation. Because otherwise you would not have communicated that apprenticeship certificate did not have the endorsement. You would have said that the necessary apprenticeship certificate was not communicated.
I have personally verified what they say what is there in the affidavit. They say it is.
We are not blaming you.
No.
Nobody's.
I'll get back to you.
There is no blame game. Be absolutely sure. You are arguing on the basis of affidavit. Affidavit has been sworn by a responsible person. So you are arguing from the affidavit, you need not fear. But if this statement is incorrect, we'll take it very seriously. November 12. Will be out, right? Keep it in the second week of November. Second week of November, anyway. Friday. Yes. Okay.
One page from the reputation is missing. What will permit me to place that?
My lord, let me check, my lord. According to my.
You do everything.
No, my lord, my brother is showing some different mind.
Paragraph 22 is not there.
In the certified copy. It is missing.
Does it contain some important fact?
So that the main paragraph was referring.
What is that? What is
paragraph 20? It is missing in the certified copy.
Okay.
No, it is in this first copy, but
in the first
not
copy.
What I have downloaded from the website, now it is available there.
No, but in the copy which I have.
Not this copy is there, but in this copy it is not.
I don't have that.
Anyway, so therefore this mistake is not deliberate. Otherwise, I would not have had that in my copy.
The certified copy it is not.
12 November. Item 28,
Yes, Mr. AG was here for a long time in that land matter. It's the same school. 18 months diploma.
18 months. Diploma.
On the list, I make just one endorsement, 18 months diploma, then I remember the facts otherwise. Monday? No, Monday would be too early.
Milord, Monday and Tuesday have some difficulty. Let it be Friday or Thursday or Friday, Milord.
This court also has difficulty.
Thursday or Friday. Oh.
We keep it on next
Thursday or Friday, Milord.
Yeah, for the unavailability of the learned advocate general, who is representing the respondents.
Friday law.
The matter is adjourned to
Friday.
Friday.
Friday is what day? On 31st.
Well, only thing is, I'm not praying for any order. Hopefully, by this time, they will not publish the result, Milord, till Friday.
Even if they do,
Okay.
doesn't matter. See, 1 day, 2 days, it doesn't matter. If you have a case, you have a case.
Right. Deep level.
Item 29.
Yes.
Lordship, the only inference, Lordship, is this, whether with the lapse of time and the conduct of the person, whether he has extinguished his right, whether inference can be done, he has abandoned his claim. The respondent here has got an order in.
See, Mr. Chakravarti, no?
Lordship.
Mr. Chakravarti, you have to tell us the facts of the case.
Lordship,
We don't remember the facts if we have not
Lordship,
heard it.
here the respondent was initially appointed in 1964 as a clerk, Lordship.
Yes.
In 72, he passed an exam in account service. At the same time, he qualified for the inspector post also. But he joined the inspector post in 1973. Thereafter, subsequently, 85 he was further promoted as assistant superintendent of post. And 1996, he was further promoted to gazetted grade B post. He reaped all the benefit on postal services. Thereafter, in 1999, he filed a OA claiming that since he has passed the account service, he ought to have promoted on the account service line. Now, Lordship, since 1985, that's post and telegraph has been bifurcated into postal service and telecommunication service.
That's not, let's see, let's come to the impugned judgment.
Lordship. Page 131, Lordship.
Just a minute. Facts, Mr. Chakravarti, you must state in nutshell, which includes everything. If you just state about that the department was bifurcated, in fact, you would, we would be misled.
Lordship.
Not your intention, but we would be misled.
His basic claim is
just
that
a minute. We are not on facts of the case. Now we are on the way in which the matter has to be argued. See, the first introduction should be, all facts should be there in one paragraph.
Lordship.
Correct. So unless you say that, then
Lordship, the order impugned before the
that's
CAT, that will make it clear,
Therefore,
Lordship.
if you
Page 79. Page 79.
No, just a minute.
Dr. Niranjan एक मिनट Now show us the order dated 26/2/2001.
26.
2001 passed in by the tribunal in OA number 135 of 1999. Or perhaps the order passed by the High Court in WPC number 6796 of 2001.
High Court order is not annexed, but that order passed in the, by the CAT that has been annexed. Lordship.
So the CAT order, the tribunal's order in OA number 135 of 1999 was upheld.
Lordship.
Your appeal failed.
Lordship.
Correct? So thereafter, many other things happened.
Lordship.
But that order passed by the tribunal, affirmed by the High Court, was required to be
Implemented. Could have been implemented, but he neither prepared an execution, neither filed a contempt for 10.
Execution. Where is the evidence that you have filed? Where you have complied with the order?
No, we have not complied.
So what execute? You won't? Are you suggesting that for every
Neither
order?
preferred any. He was sitting.
Mr. Chakravarti, that's a sacrilege. What you're saying?
No, Lordship, they really.
An order. See, it's an adverse comment on the authorities that they would wait for the contempt petition to be filed before implementing the order.
That's true.
And you are suggesting this.
That's true. We should not have waited. But Lordship, by his own conduct, he reap all the benefit of. He is retired from postal service. Lordship.
No, therefore it says therefore the tribunal says we have a strong adverse objection with respect to inaction of the respondents. When this tribunal had already passed an order on merits in favor of the applicant,
Lordship.
which was further affirmed by the High Court, and subsequently the tribunal had already reiterated the same in the year 2019.
Lordship, but there is a genuine difficulty. Lordship, can you come to page 79? The reason given by us, Lordship.
Page 79.
He's rejecting his claim.
But you were, the introductory statement of yours said something else.
Lordship, can you come to page 79, Lordship?
You're diverting the issue. I am on a different thing. You're taking me to that page. We hear very intently. So if you introduce a case, you must state the facts correctly.
Lordship, the page 79 order will make it clear, Lordship.
Yes.
The reason, Lordship, it isn't stated in paragraph 7. Was the difficulty in complying with the order at this stage, Lordship?
Where did you take the leave of the court?
Lordship.
You came in appeal. The appeal was dismissed. You never went before the higher forum.
Lordship, that's true, Lordship.
Impossibility
But
or something. So the order will relate back to the other day.
Lordship, but he too said idle, Lordship.
We'll dismiss it.
Lordship, he too said idle, Lordship. Inference can be done. He abandoned his right, Lordship.
How do you say he abandoned?
He reaped all the benefit of postal service.
That statement is incorrect again, Mr. Chakravarti.
Lordship.
Because the tribunal was again approached in 2019.
19, Lordship.
So therefore, where has he abandoned it? You have very gleefully, avoided to implement the
2019 order was simply to dispose of his representation without going to the merits of the case. Thereafter, we passed that order at page 79.
We are not getting persuaded.
Lordship.
We want to dismiss it in limine.
Lordship, kindly pay paragraph 7 of page 79. That will, Lordship, there is a genuine difficulties in implementing the order right now, Lordship.
On principle of law, your
things have been department been bifurcated. Finance and accounts have been a different gather altogether, Lordship. With a different cadre controlling authority.
Prepared in a better way on the next date, we are issuing notice.
Lordship.
We are issuing notice. Let notice be issued.
Sole
It's coming for the first time.
First time, Lordship.
Let notice be issued to the sole respondent on steps being taken. But we are not happy.
Lordship. I know, Lordship. We ought to
Because
comply with.
if we dismiss it in limine, we will observe adversely.
Lordship.
That should have been your first ground in your petition as well.
And moreover, we did not contest, we didn't find any written statement before the tribunal also, Lordship.
Let the sole respondent come here and tell many other things.
Lordship.
You will be in dock. You means your
Lordship.
client. You can't do that. In fact,
if I were the advisor, I would have advised you not to file any writ petition. I think you take a call,
Gotcha.
take instructions whether you will press it or you will withdraw it. Because otherwise, we will be under an obligation to adversely comment on your conduct, on the conduct of the petitioner. And we might initiate suo motu contempt.
Okay. But Lordship, there is a genuine difficulties in implementing the order.
Difficulty, but you can't sit and you have the cheeks to say that he has abandoned his claim.
He continued from 19.
He continued because you're a mighty state.
Lordship. No, Lordship, he is retired as a chief postmaster, Lordship. Senior postmaster.
Now, mightier than the state.
No, that's not. But it's a gazetted, senior gazetted post.
Take a call whether you would like to press it.
Lordship.
If it is not, ask him. See, we are only trying to save you.
Lordship.
If we dismiss it today in a 2 pages order, we will dismiss it, but we can't eschew. We can't prevent ourselves from passing orders against you.
Lordship.
Which we don't want actually.
Lordship.
Our first endeavor is to decide cases on merits and not comment adversely, but you have created a situation.
Lordship. That's true, Lordship. Lordship, post it.
Seek an adjournment today.
Lordship.
Better we are stuck up on that line of thinking. Let's hear
Come
it.
after 2 weeks, Lordship.
Let's hear it with a different mindset.
Lordship.
Today you were caught on a wrong foot.
Lordship.
As prayed for on behalf of the petitioner, re-notified January.
Lordship.
7 January.
Unlisted matter at 3:30. Yes, the lawyer is here. Correct.
Production list, item number 1.
Yes.
May it please your watch. One of the impugned order is at page 91. If I may place the facts in a nutshell, what that covers just. Madam.
This case was mentioned by you in the morning.
Lordship.
Let's see whether heavens are falling. Otherwise, we postpone it for another date.
They refuse. Still there. They refuse. Again, it's still there. So therefore, then therefore. That is not happened. No, he is done. The substantial justice to put on equity to be balanced. लिखा है election is started. He is the elected. No, by minus. No, he is the person. You were elected as president.
President and vice president are before your lordship.
Both of you are.
Both
Yeah.
of them.
Now that is gone. So why, what difference would it have made? You
My lord.
said that today it will become in.
On 25th, that is tomorrow, Saturday.
So meeting will be held, no?
The entire scheme of the Assam Panchayat Act is that,
Hmm.
my lord, it's the election of the president and the vice president. That's going to take place tomorrow.
Mr. Panik, in the morning you said.
Yes, tomorrow.
Tomorrow it will become infructuous.
It would become infructuous
Why?
because tomorrow in the meeting, the president and the vice president would be elected again, my lord. In the scheme of the Panchayat Act, my lord, in the first meeting, the president and vice president are elected from the elected members.
That's all right. So in that meeting,
In that meeting,
the writ petitioners were not noticed.
that is their stand.
No, just a minute. There was some reason why the meeting was deferred.
Non-correct.
Huh? Non-correct.
Non-correct.
Non-correct. Therefore, many others were not there. Another notice was issued on 15.
My lord.
And that notice also would not be correct because there has to be 7 clear days.
The
The
law is
election was held on, just a minute. Now, another notice which they say was, which you say was served upon the writ petitioners on their WhatsApp.
no, we do not say that. The state respondents say,
The state
no,
respondents.
they say it otherwise. They say that through the respective secretaries of the Gao Panchayats, they were tried to be served. When they refused, then it was sent through WhatsApp. But the Honorable Single Judge did not proceed on that premise, on the service or non-service.
Suppose notice was issued on 15th and elections were held on 21st.
My lord.
No clear 7 days.
So may I,
So that also is wrong.
well, may I invite my lord's attention to the act and the rules, which say otherwise.
Let you face the election again.
But if lordship takes up the act and the rules for a moment, it does not say so. That's
And
what
it
my,
doesn't, this case doesn't die otherwise. We are not going to pass any order in the absence of respondents now. We'll just say, or do we explain then this case dies a natural death?
well, if I'm,
If we give our introduction, your case dies a natural death today. A decent burial today.
no, I squarely understand, but the way the place I'm put, my lord, if I'm trying to at least persuade my lord,
Number one, this court has objection to this case being listed today on your mentioning. That tomorrow it will become infractious.
if the new president and vice president are elected,
Issue remains, no?
very well.
You were elected.
With that observation, if it
Then
can
we
be-
decide it now. Why? We have heard you for 15 minutes. Why shouldn't we
No,
decide?
not even address me, lord, on the law point, my lord. If the issue remains very
Law
well,
point, section 48.
no, I would address me, lord. If
Section 48, issuance of notice being served.
Section 48
WhatsApp
has-
not being the correct mode.
my lordship, section 48 has two parts. The first part is when the
Tell
meeting,
me one thing. Now notice, you would be challenging the notice. You'd be saying that this statement is incorrect, that they were not noticed.
no, I would not be on that. I'll
Because,
not be on that. I'll invite my lordships to section 45, rule 48, and the notice itself. By the record, what I would say is the stand taken. I am not on service or non-service of notice. Let me put it this way, not 7 days notice whether required or not.
where's the elections, Mr. Banik?
But I
If you
already have a
succeed,
return
come-
candidate.
If you succeed, come and withdraw. If you don't succeed, press this petition.
That
Face the elections tomorrow.
that observation be there, my lord. Otherwise,
What observation? This is an oral statement to you. What observation? Face the elections tomorrow. If you succeed, you just withdraw this petition. If you don't succeed, come back to us. Say that I was appointed wrongly. I was divested of my powers.
but however, my lord, as I went through, my lord, I could see that so far as an adjourned meeting is concerned, under the act, there is a provision which
More
does not go
important
for 7
matters
days notice.
More important matters which were listed today. You have stolen a march over that.
I'm
by
sorry for that.
mentioning it
There's
as body.
25th, tomorrow is the day. Man.
My brother is strongly of the view that it should not have been allowed in the first instance to be listed at 3:30. Strongly of the view. We did not ask you for the details. We just, and in fact, we pointed it out.
True,
that
true.
is
I
the
said
sky
tomorrow the
falling
meeting is there,
by
otherwise
evening.
nothing remains.
What do you want? You want to withdraw? You want an order on merits?
No,
Or you
withdrawal
want to
would
try
not
your
be
luck
proper
elsewhere?
without instructions. Would
No
not
notice,
be
we are
proper without
We're
instructions.
not issuing notice now.
Let it roll over, my lord. Let it roll over to a different date.
See, at times, granting indulgence also becomes difficult. We have heard you, Bishop, just now. Huh? What ground are you suggesting?
But very well, my lord.
Section 48.
But section 48, prior to that, section 48 has two parts. I squarely understand what is falling from your lordship, but since I'm trying to persuade, 48 has two parts. If lordship would have the Panchayat Act for a moment, you know.
Looking at your level of preparation, we think that we should give you another time. Let this matter come up for consideration. Sometimes in January. With the liberty to you to have it preponed in case you want to withdraw.
9th January.
We are not saying, but you can file an application IA for withdrawing. I think you'll succeed if you are a popular person.
Obliged, lordship.
Huh? All right, yes. January, huh? 7 matters left, we'll hear as long as possible. As long as we don't run out of our energy.
Item number 30.
Acha, we have another bench also.
Another point. It may be.
Any urgent matter, this will be reassembling with a different composition, Mr.
Look,
Chaudhary.
there is one matter. Today we can wait, there's no issue, only clerk will have it date fixed.
I will fix it. We'll fix all dates because we have,
Item number below 35 to 37.
what is that? Dr. Satyajit Paul. I think we have heard this matter sometimes.
Yes, once, yes, once lordship.
Next week?
Yes, next Friday, Mr.
Next Friday.
Thursday or Friday.
It is okay.
Friday, let it be Friday. Or maybe following Monday.
We are not.
I know. Six. 10th of November.
Yes, 10th of November. 35 to. Can it be on 13th?
NCC.
Mr. Chaudhary, can it be on 13th?
Yes, yes.
Not 10th, but 13th.
13, 11. 13, 11. Thursday, November.
We keep it to be on the safer side because there are two conferences where I might get stuck up.
Yeah, 10th, 13th.
Okay, you're talking of November.
November,
Oh, why not? November 13th. November 13th.
13 November.
13th of November. Let 35 to 37, let these matters be listed, click the number. All right. The other matters? Which odd matter?
In item number 41, madam, I pray for a date on the second week of.
Please take the dates from him. As far as possible, accommodate the advocates as far as possible, whatever is their choice date. We'll be coming back after 10 minutes, after 5-10 minutes in a different composition.
The urgency mail also on 31st of October.
Which matter?
This call mail item to 30 before
Item number 31.
30.
This is branch post office,
Yes,
branch
yes,
post
yes,
office
ma'am.
removal.
Yes, well, it was court reinstated direction was reinstated, my lord. So they may file contempt also, my lord. So this,
Achha, you are appearing for Union of India.
yes, my lord.
They must file contempt.
So, my lord, on 31st of October, my lord.
Yes, on 31st of October.
31st.
31st of October.
Item 38. Let it come on 30 November.
You have said, take your dates.
Adjournment request.
Yes,
May please, the lordship. I beg to mention item number 1 of the daily list to lordship.
an adjournment slip has been circulated.
Lordship. My lord,
There is no real objection on the other side. Let this matter be listed. Sometimes in November. November last.
deeply questioned.
Yes.
26 November. Oh, sorry, 26. 20 November, 20. Daily list for orders item 2.
May I please, your lordship?
Yes.
Review petitioner was appointed as a statistical officer on the recommendation of the APSC and for the due process in the 1992. Thereafter, he was promoted to the post of the research officer in the year 2003 as per the procedure and seniority.
No, that's all right. But you need not address us on facts. Now, the principal decided what review do you want? Why do you want a review?
No, your lordship, some relevance documents not to be annexed in the writ petition due to hurriedly filed this writ petition as the director of economics and statistics advertised.
You're Mr. Talukdar.
Mr. Tata, yes, my lord.
You're Mr. Talukdar.
Yes, my lord.
So, Mr. Talukdar, the moment you say this, that the decision was passed on a hurriedly drafted writ petition, then you don't fall in the category of review for the reason that you will not be allowed to have to re-argue the case. That's one of the basic principles.
Your lordship, there is a, I am going to deprive of the.
Well, will not take such a strong stand. But then tell us what is so bad? What is the error apparent on face of record? What principle of law has been overlooked by the
Yes, my lord.
honorable learned judge? Tell us. For the post
For the post of the Director of
for
Economics
the
and
post of Director of Economics and
And
Statistical
Statistics.
Department, whatever, the stream commerce was not there.
now commerce is subject.
Just a minute. So this advertisement comes when? After 5 or 6 years of the amended rules. Right? So after 5 or 6 years of the amended rules, I don't think there is any midway change or any change which adversely affects you. They are within their authorities, the government, the recruiting body.
No, your lordship, I have a requisite qualification.
Requisite qualification you don't have because you have you have masters in some subject of commerce. Though the judgment talks about commerce as a stream and not a subject, but then we'll not even go to that.
No, no, your
Question is this: the earlier rules were which? Earlier rules were of the year. Earlier rules were of 1973.
No, your lordship.
1973. The rules were amended in 1995.
No, your as per the-
Answer the question, Mr. Talukdar. No, we will not permit you to re-argue. We will permit you, but then the law does not permit us to hear re-argument. The advertisement was issued when? 2023.
23.
It was not that after the interview, after the advertisement was issued, that the amendment was brought about. It's not your case.
Yes.
What? Yes, no.
No, your lordship, I have also, I annexed the certificate, annexure B.
बहुत मुश्किल है. Look at this. If we had heard this petition, we would have imposed cost for raising a frivolous plea. You are questioning the constitutionality of a rule without any ground whatsoever. No competence is questioned. No rights have been violated. You only say that it was earlier that, therefore it should remain. So do we decide constitutionality on such issues that you are ousted from that for the post of director? Is it complete exclusion? Take down. The present, anything else that you want to argue? Let me not force you or
Your lordship, kindly consider I have the requisite qualification as
who
per my,
denies?
as per my certificate.
Who denies that? The judgment does not deny that you had the qualification of masters in commerce.
No.
And if masters in commerce, and if 1973 rules were not there, and the advertisement would have been issued in accordance with 73 rules, then perhaps you were eligible. But today you're not on 20
No, your lordship, there are similar the judgment is.
there can be no judgment.
No, no, your lordship, may kindly consider. For the answer, only 4 months service is, I am going to be retained. Now additional director. Your additional director post is holding.
We have heard Mr. Talukdar, learned advocate for the review petitioner, who has questioned the impugned judgment on the ground, solely on the ground, that with the judgment, with the aforenoted judgment, his
chances of being appointed as a director, comma, the highest office in his grade, would be over as he is to retire shortly. The petitioner had questioned the advertisement dated 25/8/2023, as also the Assam Economics and Statistical Service Amendment Rules 1995, on the ground of rules being arbitrary and exclusionary. The facts necessary to be stated here are that the petitioner was appointed as a statistical officer, whereafter he was promoted to the post of research officer. He rose to the rank of senior research officer, then joint director, and finally additional director.
Now additional director.
And later additional director, with his seniority placed at serial number 5 in the gradation list. In the meantime, an advertisement was issued by the Assam Public Service Commission for selection to the post of director, economics and statistics. Economics and statistics under the Transformation and Development Department of the Government of Assam. The Assam Economic and Statistical Service Rules 1995 provided that the eligibility criteria for candidates seeking appointment on the post of director would be masters in economics, statistics, and commerce. However, in the amended rules of 1995, the stream of commerce was left out. Perhaps for the reason that it was wrongly included in the eligibility criteria for the reason of commerce being only a stream and not a subject in particular. The advertisement in question, dated 25/8/2023, had been issued much after the amended rules in the year 1973. The contentions of the petitioner were repelled by the impugned judgment, holding that taking a decision with respect to the eligibility criteria is in the domain of the recruiting body, is in the domain of the government/recruiting body, in which there ought not to be any interference by courts. So far as constitutionality of the amended rules of 1973 is concerned, the judgment clearly postulated that the constitutionality of an act could be questioned only on grounds of legislative incompetence, or the act/rules being violative of any provision of the Constitution, or for the reasons which have, become redundant or is arbitrary. If it is found that the legislation falls foul of federal distribution of powers and contravenes the fundamental rights, then only
any interference by courts could be made. The constitutionality of an act/rule cannot be questioned lightly. And that also on the ground of that being to the detriment of an applicant who stands excluded from the zone of consideration because of the amended rules. There is not an iota of doubt that the amended rules were within the competence of the state legislature. And therefore, there is the presumption of constitutionality of the rules in question. Even otherwise, it need not be reiterated that the validity of plenary legislation has to be decided purely as questions of constitutional law. The petitioner now seeks to re-argue his case under the garb of review without raising any new ground or any newly discovered fact which he could have known by exercising some diligence. There is no error apparent on the face of the record in the judgment to entertain the present review petition. It is trite that review jurisdiction is very limited in scope and it cannot be treated as akin to an appeal. The primary object of review is to correct patent errors, inadvertent mistakes, and manifest injustice, but not for enabling any party to re-argue his case or invoke the sympathy of the court. The Supreme Court in Messrs. N.I. Caterers versus Lieutenant Governor of Delhi, 1982 SCC 167, semicolon, Meera Bhanja versus Nirmala Chaudhary, 1995 1 SCC 170, Lily Thomas versus Union of India, 2000 6 SCC 224, Kamlesh Verma versus Mayawati, 2013 8 SCC 320, has clearly laid down that a review jurisdiction has to be exercised strictly within the confines of the scope and ambit of Order 47, Rule 1 of the CPC. Stop. It is an exceptional jurisdiction which must be exercised sparingly. Stop. There is yet another aspect which has to be taken note in the review jurisdiction, namely the finality of a decision, which is an essential feature of rule of law. Stop. We have not found that any provision of law or an essential fact has been overlooked, or an essential fact or a binding precedent has been ignored in any manner whatsoever. Finding this petition to be wholly meritless, we dismiss the same. Dismissed.
Item number 3.
For non-conforming. Please.
Delay condition, your lordship.
You're ready for arguing the review today?
Today, not my lord. Fix another day, your.
We'll fix another.
Ma-
For the, do you wish to contest this 27 days delay? Okay, we have heard the land counsel for the parties. For the reasons stated in the application, the delay of 27 days in preferring the review petition is condoned. The application stands allowed. Let the review petition be processed and be listed
Same day.
on same date.
2011.
Mass of.
Application stands allowed.
Item 4.
Yes,
There's a delay in this as well, my lord.
delay will condone. Are you ready on merits?
My lord, it looks like I'll miss my flight, my lord. 90% chance I'll miss my flight. The 10% will also be gone, my lord, if I argue, my lord. Any date, my lord, we can go to the same date, my lord.
Is that co-warranto?
Co-warranto issue, my lord.
Where is the scope of review now?
My lord, the office.
And the person is retired, no?
No, he's not. He's on extended tenure, my lord, which is coterminous with the term of the government,
And the
which
government
is squarely violative of the OM, my lord.
All right. We will not make you miss your flight. Where are you off to? Delhi?
Delhi, my lord.
All right. The same, condone delay of how many days?
68 days, my lord.
Mr. Sharma, Mr. Sharma, no objections. We cut down the delay process.
2011.
9.
2011.
Deeply obliged, my lord.